scheduled we're scheduled to start for 1 o'clock, and we still have a few participants who haven't come online yet. So I'm going to kill a couple minutes just at the beginning to give other people a chance to get logged in, and to let you know also that this session today is being recorded, so that if by any chance you need to leave the session to go take care of some important business for a couple minutes, and or if you want to go back and review some of it before you write your challenge exam, and I'll go over the process for that later on, you will receive a notification of where you can go back and watch this session again. Hopefully we do a good job today and you don't need to do it again, but it will be there for you for learning purposes as we go forward. Again, everyone has come on to the line muted and with their cameras turned off. I think it defaulted that way. When we go through our session today, I'm going to ask you if you will keep your microphones muted, so that if in the event the phone rings or people walk into your office, we don't have some strange background talking and things going on. But I don't monitor the chat session actively while I'm doing the presentation. This is because I'm thinking, and Jennifer's not going to be necessarily on the line throughout the whole session to watch and monitor some of the questions in the chat. So if you have a question while we're going through our presentation today, please, and I'm encouraging you to do this, please click on your profile and unmute your microphone and just jump right in and say, hey, Steve, it's me, Marcia, or it's me, Callie, or Sarah. I've got a question about that. Do you mind? And I will stop and deal with your question on the spot. If it's something that I know is going to be answered in the next slide, I'll politely let you know that, and we'll just kind of roll along to it. But having you jump, sometimes I just say things and I think I said it right and I said it wrong, and I can confuse people. That's the way it goes as a presenter when you have to talk for 3 hours at yourself on the computer. So please, don't be shy. If you have a question, unmute your microphone and jump right in and ask the question on the fly. At the end, we'll have an opportunity for questions also. And finally, at the end, I'll also give you my email address. And if you are reviewing your notes and you think something was confusing or you want to get some clarity, then please feel free to send me an email and ask your question. And if it's a really great question and that I think everybody should hear the answer to, we will make sure that we keep your question anonymous so people don't know who asked the question in case you've or something specific about your business. But we'll try to share the information with everyone, so you might get the benefit of somebody else asking a question afterwards. Again, we got a couple of people who are going to probably come on during the session. We've got a fairly large group today, and I know that everyone is not yet on the line, and I just want to check to make sure whether I need to click on anything at this point in time to let a few more people into the room. We're going to, from a scheduling standpoint today, we're going to try to finish by 4 o'clock. If we go over by a couple minutes, don't worry. I'm trying not to go over by more than a couple minutes, but it'll just be time saved tomorrow when we do the second part of the legal aspects seminar. It's kind of broken down into a couple areas, but there's a little bit of overlap, so I can remove some things from tomorrow to make sure that we get finished on time. And one of the best things about a good presentation is that it gets started on time and finishes early. So welcome. First, I want to congratulate you for making the choice to join the CPC session. The Certified Personnel Consultant Certification designation is the only professional designation that is available in Canada. It is modeled after other CPC similar designations originally in Australia and the United States and the United Kingdom, and Canada has and ACSESS is responsible for the offering of the CPC program and the management and maintenance of the CPC program. Now, this particular slide that I have in front of you is, I think I've updated it, I don't know how many times, but for whatever reason, this slide is a little bit incorrect in the sense that there are 5 modules that are required in order to receive your final CPC designation. There is a new module in sales, recruitment, staffing, industry sales. And so it kind of goes down beside the recruitment and selection, because the recruitment and selection and sales, it's either or both. Most people do both, just because they're both really important. But some people are only in sales and some people are only in recruitment. And so the business practices and ethics, legal aspects of staffing, health and safety and legal aspects of recruitment are all mandatory. And then one of recruitment and selection or sales is the 5th that you should take. And as I mentioned to you, since we've introduced the sales program a year ago, 100% of the people have taken both. So I encourage you to do that also. When you've completed the 5 or 6 CPC modules, then you're eligible to take the CPC challenge exam. And the challenge exam is a multiple choice exam that to give you some insights, we're going to be talking about some things in law that differ from province to province, and also would require some memorization. So, for example, the number of weeks that it takes to be eligible for something, or how to calculate overtime or vacation pay. And you don't need to memorize these things. The exam will ask questions in general so that you know that it is a topic that is covered, and that it is covered under various legislation where it's covered. And nobody expects anyone to memorize the details that often change in legislation. But it's important to know that it exists. So if, for example, we were to say that notice of termination is a requirement in law, then to know that there is a requirement in law for notice of termination, and that there are qualification criteria, and that it is calculated based upon the amount of time that you spend with the company. But to actually go back and figure out how much time and how much notice, we don't expect you to memorize those things. Those are the kinds of things that you need to know, that you can always go and look them up. And that's what the important thing is. So the ACSESS, by the way, is the only industry association in Canada representing the staffing services industry, including recruitment firms, search firms, executive search, management search, professional search firms, recruitment companies, and also temporary and contract staffing services. The companies join ACSESS, not individuals. And so as an individual employed with a member company, you are automatically a member, an ACSESS member who is eligible to receive the resources that are available through ACSESS, including many of the things that are on their website, and training materials and training courses, and attend conferences and so on and so forth. But it is the member company that qualifies. And each member company, when they make their application to join ACSESS, is required to make a commitment to understand the association's mission statement, which is to identify and communicate and monitor industry standards and ethical practices, to positively influence and protect the regulatory and business environment for our industries, for both member companies, customers, and the candidates and employees that we serve. To promote the credibility and visibility of the industry and to build and to promote it with businesses and government and the general public, and to provide all members with the strategic support, such as the kind of support you're receiving today. And each member company is required to make a commitment to uphold the ACSESS Code of Ethics and Standards. And, I'm not going to read it for you. It's here on the screen for you. But a member company, aside from all of the other things like being in good standing with respect to the government and their taxes and their workers' compensation and all the things that not having criminal backgrounds, all the things that are required in order to meet the standards, the final thing is that the member company makes a commitment to uphold the Code of Ethics and Standards and to make sure that this Code of Ethics and Standard is presented somewhere on their website or in their company offices. Today, we're going to talk a little bit about our learning objectives, which is primarily I'm just going to move some things around on my screen here. By the way, I'm clicking on something, so I apologize. Which is understanding the employment standards legislation, which is going to be a good part of the time that we spend today, to be able to identify employee status, co-employment, joint employment, and the liability issues that come along with having two employers or co-employers, understanding who the employer of record really is and some of the ramifications of misclassification of that. We're going to talk about some of the ways that the laws apply to each other, and we're going to also look at some ways that we can make a commitment to uphold these standards and apply it to our business. So to start off with, employment standards. Normally, if we're in a group, we can get people to show their hands, about how you might rate yourself with respect to your knowledge of employment standards. And I think it's pretty safe to say that most people, I'm gonna generalize, that most people in the recruitment and staffing services industry understand that this is a very important part of what we need to know in order to be a professional supplier to our customers and employer for our workers and recruiter on behalf of our customers. I think that those in the temporary services, my impression is that those in the temporary services side of the business, of the industry, tend to have more reason to get into the details of employment standards. And those who are exclusively and only in the recruitment side of the business and the permanent placement or recruitment side of search side of the business tend to not spend as much time on it, but maybe more time on things like their code of ethics and standards, or on lawful on discrimination or prohibitions in law for recruitment practices. And so it's important that we know the law. We want to know the law so that we can protect our customers and reduce their risk, to protect our employees, to ensure that they receive the minimum entitlements that they're entitled to under the law, to improve our productivity, and to eliminate misunderstandings and problems that come as a result of people doing things the wrong way and having to solve problems. It's always better and easier to do things right the first time than to try to go back and fix them. To protect your reputation and to limit your liabilities from unwittingly violating the law. By the way, whenever we typically run into an issue with a staffing services company or a recruitment company who's potentially being accused or alleged that they're not following the law, it's usually knowledge. Usually, if the association contacts people and talks to them about a business practice, it's kind of like, I didn't know that, and we can easily fix that, and they very quickly attempt to do it. We want to earn the respect and dedication from our clients who rely on us, and to differentiate us from companies in the marketplace that are not reliable and credible. And we want to retain our workforce, so we have to treat them properly. And of course, we've already made a commitment to the ACSESS Code of Ethics and Standards, and so following the law is the minimum requirement. So let's talk a little bit about the laws, because this is going to come up several times in our conversation today. And let's start first off with constitutional law. So in the Charter of Rights and Freedoms and the Canadian Constitution. And this is not to give a legal course, but this is, in layman's terms, what I call the law of laws. So the Canadian Constitution And the Charter of Rights and Freedoms tells us who's responsible for laws and what jurisdictions provinces and municipalities and the federal government and the courts have over which kinds of laws. So what jurisdictionally, who has the authority to make those laws and to implement those laws and to uphold those laws. It gives us some, in the Charter of Rights and Freedoms, it gives us some real basic high level kind of standards around privacy and around human rights to make sure that laws aren't created that would be in violation of the charter. And so you hear the term, there's a charter challenge. That means when they say there's a charter challenge, that means someone has written a law or interpreted and applied a law in a way that they felt was unconstitutional, that didn't follow within the spirit and the exact wording, the intent of the Constitution or the Charter. So the Constitution and the Charter of Rights and Freedom is the law of laws. And then, of course, we've got statute law, which are those kind of laws which we usually think about. Those are the laws that tell us how fast we can drive on the highway. And they're the laws that tell us about about employment standards. And they're the laws that tell us about food safety and all other things. So if someone violates the law, that they can receive a ticket or they can go to jail if they violate a statute in the law. And those laws are written by and agreed to by our politicians, our elected politicians, and we have a process in each of the provincial legislatures and in the federal government on how a law is introduced, how it's reviewed in committee, how it goes to first, second, third reading and royal assent, and in the case of the federal government, how it goes through the Senate for second level of approval. And so the statute laws are the laws that governments create to try to form our public policy and our public discourse. And then we've got this thing called common law. And you often hear about common law. For example, you've heard of the expression, a common law marriage. So, for example, basically the courts have decided that when we all have something in common, we don't need to have a statute. We don't need to have a written law written by our politicians. But the common law is when the courts have said, hey, listen, if you're married, if you live together as husband and wife, for example, or like husband and wife, but you didn't go get a marriage certificate and you're living with each other for 2 years or 5 years, as if you were married, then a lot of the things that would exist in marriage, like, for example, the rules of a divorce or child custody, or the separation of assets on a divorce, if those, or whether you're entitled to spousal benefits or death benefits under an insurance policy, that if you've lived together for a certain period of time, the courts have said, we all have this in common. And so the courts have decided that if you do this in common, then it's the law that you're actually treated like you're married. So we call it a common law marriage. Well, there's lots of things that exist in employment law that are common law. So these are things like the determination of whether or not a person is an employee or an independent contractor. The courts have said, hey, if it looks like an employee, if it smells like an employee, and it tastes like an employee, and you've got these 7 criteria that are met, then you don't have to have a contract or a statute that says you're an employee. The courts will determine in common law that you've met all the criteria of being an employee. So we're going to talk a little bit about common law as we move forward. And then finally, we've got contract law. And contract law are things like the marriage contract. And in this case, for us today, things like the employment contract or the customer service agreement. So these contracts become lawful obligations between the parties that sign the contract. And so an employment contract cannot have a standard in it that is lower than that in common law or lower than that in statute. In other words, if the Employment Standards Act says that you are entitled to 4% vacation pay, you can't write a contract that says you're only entitled to 2% or you're not entitled to any vacation pay. So contract law says that so long as the contract, the terms of the contract, meet the common law and the statute law standards, and they don't violate the principles of the Charter of Rights and Freedom and the Constitution, then everything else that's in there that's written between two parties and agreed between two parties is a contract, and it becomes lawful between those contracts with those two parties. And if one breaches the terms of the contract, then they can go to court to fight it in court because that person violated the lawful part of their contractual obligation. So we've got four parts of law: constitutional law, Charter of Rights and Freedoms, high level law of laws. Statute laws, those that are written by our politicians that are intended to design minimum standards and obligations that help define our objectives in a society. And then we've got common law, those things that aren't written, but everybody knows is a standard that we uphold. And then finally, we've got contract law, where we get into the details of what goes on between two parties. And so the Constitution defines, for example, in employment, who is whether it's a federal government or a provincial government that will write the laws, the statutes around employment. So employment is generally defaults to be the responsibility of the each provincial government, except for the Constitution defines federally regulated industries. And so things like banks, air transportation, interprovincial railways and canals and pipelines, telephone companies and cable companies and television companies, these are examples of things that doesn't make sense that every province would have a different standard. And so the Constitution says, hey, if it's got to do with banks, only the federal government can determine what the rules are for a chartered bank and whether you qualify to be and whether you are a chartered bank. Only the federal government can determine what the rules are around air transportation. You don't want to have an airplane in the air and it crosses over from Quebec to Ontario to Manitoba to Saskatchewan to Alberta, and every time it crosses over a provincial line, that new rules apply. And so the federal government has determined that there are certain industries, the industries on the right-hand side of this screen, are federally regulated. And so if there are employment issues in a federally regulated industry, then the federal government is responsible for writing the employment standards or employment laws that apply to these industries. Then every other industry that exists, manufacturing companies, service companies, restaurant organizations, IT companies, software developers, staffing services are all provincially regulated. And it doesn't matter that your customer is a federally regulated customer, and this is where it can get confusing. You would have, for example, a provincially regulated staffing company supplying temporary workers to a federally regulated bank or to the federal government. And the rules don't change for the staffing company because the customer is federally regulated. It is the employer who is regulated, not the customer, to determine the regulations. And so we've got these different provinces with their provincial legislation, and each province sometimes uses a different name. Like, for example, in Alberta, it's called the Employment Standards Code and Regulations. And in Ontario, it's called the Employment Standards Act 2000. And out east, I think in Nova Scotia, it's called the Labor Standards Legislation. So they're all given slightly different names, but they're all fundamentally the same. And as we talk about employment standards today, we're going to give examples a lot from Ontario because most people are on the line on the call today are from Ontario. But if you're in Quebec or if you're in Saskatchewan or Alberta, I think we've got Saskatchewan person on the line today and a couple Quebecers on the line today. Never fear. The important part is that you understand as we talk about some of these things that if it exists in Ontario or in Manitoba or Alberta or Quebec, it probably exists in your province too. And if it does exist in your province, the principles are probably the same. And if it might turn out that, say, for example, the calculation is slightly different of something or the details are slightly different, but the principles are the same, and it's important for us to know that. So we want to know which laws are applicable to us in our province. It is the employee's workplace and that matters to determine which province it applies to. And typically we use the phrase paid from or through. So you could have, for example, a company in Alberta that sends engineers to Saskatchewan to work for 3 months. But just because they sent a temporary worker to Saskatchewan for 3 months, the person was paid from or through an Alberta employer. And so therefore would be Alberta's employment standards that applied. And the only way that Saskatchewan's rules would apply is if they had an office in Saskatchewan. Today's world, virtual office, it gets that can get a little muddy as to whether or not you actually say we have an office in a virtual office in Saskatchewan. But the argument can go both ways, that there is a virtual office in that province, or there is an actual office in that province that the person is paid from or through. So this cross-border supply, you always go to where the employer is. We've got this federal versus provincial. It doesn't matter who the customer is, it matters who the employer is. We also have issues with respect to an employee versus an independent contractor. And so employment standards apply to employees, and they do not apply to independent contractors. And so there are definitions in common law that will tell us whether a person is an employee or an independent contractor. By the way, very well established definitions and criteria to determine whether or not an employee-employer relationship exists. And also, if there is a customer and a supplier, these same definitions in common law will determine which of those is the employer. But the important thing is that we understand what the definitions of an employee are and what the definitions of an independent contractor are, and what the definitions of which of the parties is the employer. And in Ontario, because it often got confusing, in 2017, they passed a law that said that if you're a temporary staffing company and you're supplying people to your customer, there's no question as to which of the two parties is the employer. The temporary staffing company is always the employer, as long as it's traditional staffing. I mean, i.e., there's a paycheck written or a check written by the staffing company, paid to the worker. The customer pays an invoice to the staffing company. Then in those traditional examples of a staffing company services or temporary services, then the staffing company is the employer. It doesn't necessarily say that every worker is an employee. So there are going to be circumstances when the type of relationship that exists, that the person does actually, in fact, qualify to be an independent contractor, where neither the customer nor the staffing company are the employer. So, to say this differently, in Ontario, in order to stop the arguments as to who the employer is, then it goes like this. If the person meets the qualification of being an employee, there is no question that they are always the employee of the staffing company, not the employee of the customer. So if an employee relationship exists, that relationship will be with the staffing company, not with the customer. Most provinces don't have this codified into statute, so they rely upon common law determinations to determine whether there is an employer-employee relationship or a independent contractor relationship. So this, once you are deemed to be an employee, by the way, I'm going to remind you and encourage you that if I confuse the heck out of you or say something silly and it doesn't make any sense, please just unmute your microphone, jump in there, ask me a question and ask me to restate it differently so that I can help clarify things. If there is an employer-employee relationship, then the Employment Standards Act or the Employment Standards Code would apply. So if it's a federally regulated industry, then the federal employment standards legislation would apply. And if it's a provincially regulated industry like us, then the provincial standards would apply. And of course, you would go to the province of where the person is paid from or through, where the employer office resides, and you would pick that province's legislation to determine which applies to the worker. And there's a lot of things that every employment standards legislation has in common. First off, all of them have some requirement about posting and informing your employees that they have rights. And all of them deal with hours of work, things like how many hours a day and how many hours you can work before you get a break for lunch or eat what they call an eating period or a rest period. And interesting enough, I mean, most provinces don't have a rest period in their legislation. So to say, oh, we get a 15-minute coffee break in the morning, half an hour for lunch, and a 15-minute coffee break in the afternoon, it is only the lunch that is legislated. It has to occur within 5 hours. You can't ask a person to work for more than 5 continuous hours without getting an eating period break. But the rest breaks, like the coffee breaks, those are usually a policy that are often covered in the employment contract. The payment of wages, how they're paid, when they're paid, how frequently they're paid, the method of payment, that's usually covered under employment standards. Things like the rules around tips and gratuities. Alberta just introduced a new law this year that says that an employer cannot withhold tips and gratuities, has to be paid out immediately and cannot be distributed, in certain ways. So there's certain things around tips and gratuities that are covered under Employment Standards Act. Every time we hear about minimum wages, what's the minimum wage in your province? The federal minimum wage, and we'll talk about that in more detail. Those are set by provincial legislation, are often always included in employment standards legislation. Things like leaves, pregnancy leaves, personal emergency leaves, family caregiver leaves, family medical leaves, critical illness leaves, child disappearance leaves. Ontario recently introduced, I'm not sure if it comes into effect in January or whether it just came effective. I think we've got a screen on that later on. Just introduced a new leave for adoption. So when a child is being adopted out or in to a family, the parent can take an unpaid leave for a certain period of time and have their job guaranteed back after that time period. So different leaves are written into it. Public holidays, Christmas Day, Boxing Day, New Year's Day, Easter, Good Friday, all of these public holidays, which we'll talk about in more detail, are all included in the legislation. Vacation. how much vacation or how that translates into money is in the employment standards legislation. Hours of work, I've got hours of work here. One's got to do with breaks, one's got to do with um, how many hours in the week or in a 2-week period, and whether you can bundle times together, and how many hours break you get between shifts. Other parts of the legislation is how many hours you can work in a row and when you get food breaks. So there's different parts of hours of work. Termination, layoffs, severance pay, equal pay for equal work, which has to do with gender. In some provinces, and particularly in Ontario, there's special parts of the legislation that deal with temporary help agencies, sometimes with licensing, sometimes with other requirements. We'll get into some more details on some slides as we go through that. And of course, all the things about the penalties and compliance and who's got the authority to prosecute people and to enforce these laws are all in the employment standards legislation. This Retail Council of Canada, by the way, I've always, for years, have used it to get a real quick update of like what's the current status with respect to minimum wage and a few other things, because the Retail Council of Canada tries to stay up to date and they publish it all in one place. Of course, if you want to do it individually and you want to drill into the real details for Manitoba, you'd have to go to the Manitoba Ministry of Labor site. And if you're Ontario, to the Ontario Ministry of Labor site to get the details from each province. But this Retail Council of Canada has got a great website, retailcouncil.org, where you can look these things up and actually see them on a map. So you can see here, as of the beginning of October, the first day of October, the different minimum wages across the country. And there's some pretty significant disparities. Like, for example, Saskatchewan, $15.35 is the minimum wage, whereas, Ontario, $17.60, Yukon, $17.94. Whole dollar difference to move over to Northwest Territories. So we'll also see in, I think, one of the next slides that some of the regions, like, for example, in PEI in the Atlantic provinces, they've got a mandate to be the highest paid minimum wage of the Atlantic provinces. So for the same reason as I explained earlier, the jurisdictional requirements of employment standards, federal and provincial. Federally regulated industries like banks have had a minimum wage that has been increasing every year, and they've tried to tie this minimum wage to the consumer price index. So if there's a 2 or 4 or 6% increase in the consumer price index, and once a year in April, they will increase the minimum wage to match that, rounded to the closest 5 cents. So you can see that in April 2025, the federal minimum wage moved to $17.75. Now, by the way, when you think about banks, airlines, Bell Canada, TELUS, communication companies, I mean, not too many people are making minimum wage. So it's somewhat less of a controversial issue, but it can happen. So the federal government's got stake in setting a minimum wage also. So some other examples of minimum wage. So Manitoba has an annual adjustment based upon the consumer price index. BC minimum wage increased in June to $17.85. The annual adjustment of consumer price index. PEI, I mentioned, has got a mandate to have the highest wage of all the Atlantic Canada provinces. So they go at it every year and debate it and talk about it in their provincial legislature. So it's a 2-step process for them to look at all of the provinces. They look at their own, then they propose legislation, then they debate it, and then they come up with this annual review to make sure that they're not falling behind compared to their. They don't want to lose the few people that they have in the province to head across the bridge and say, for example, go to Nova Scotia to find employment over $1 an hour. So they're kind of competitive with their minimum wages. The minimum wage increased October 1st. It says to increase in Manitoba by 20 cents, 1.1%. And again, that was based upon consumer price index. Basically, what happens is that the minimum wage is used to be decided by provincial legislatures who decided for political reasons, often discussed during election campaigns. If you elect our government, we will increase the minimum wage to a certain number. Then they debate whether or not this is good for business or whether it's good for people, and governments would get elected and then they would implement it. And then in the last 5 to 10 years, many of them have said, well, let's just get this off the table. This is a political football that goes back and forth, and business leaders, every time they hear increase of minimum wage, think this is bad, and employment groups and employees think this, higher minimum wage is good. Unions think it's good. And so in order to make it a non-negotiable issue, many of the provinces have introduced legislation that says forever, or at least for the next 10 years, for the next 5 years, every year we will increase it by $1, or every year we will increase it by the percentage equivalent to the consumer price index. So at least people aren't losing out to inflation. So there's nothing in the Constitution that says how often it must be reviewed. It only says that it's the purview and responsibility of the provinces for provincially regulated industries, and for the federal government under federally regulated. And so instead of politicians arguing it out every year or two, or fighting it out every election, they often pass legislation that say, here's the process that we're going to follow, and it's just going to automatically happen. There are different minimum wages for different industries. For example, during pandemic, personal support workers had a different minimum wage than other industries. In ages and maybe some other more risky industries from a health and safety standpoint have different minimum wages. Every province is a little bit different. Restaurants and industries with tips sometimes have different minimum wages. So it's important to understand what the minimum wage is in your province and how it applies to you. The employment standards legislation also deals with these. I talked about payroll requirements earlier. So it talks about things like pay periods, that it requires a set schedule. And that set schedule, I don't think can be once a year. I'm not really sure. Different provinces say it can't be longer than a certain period of time. But some of them are monthly. Some of them are bi-weekly. Some of them are semi-monthly. Some of them are weekly. Some people get paid by the day. But the important thing is that payroll periods need to be set and defined. An employer can't just say, oh, we don't have a lot of money this month, so we're going to pay you once a month instead of once every 2 weeks. It needs to be a well-established, written, set schedule, and money must be paid within a certain period of time after the time it was worked. When a lot of pay legislation, when it was written, we didn't even have direct deposit. Everything was done by check or cash. And so when direct deposit came along, they said, okay, well, let's at least make sure that the direct deposit goes in the name of the employee. So you can't have, for example, a 17-year-old having it go into the name of their father, or for a woman to have it to go into the name of their husband, or for a high earning person have it go in the name of their retired mother who doesn't have an income, so they can distribute their taxes and things differently, so that one person they could distribute their income. These things are not allowed. It must be in the name of and attributed to the actual employee. Can't be in anybody else's name. We have to receive they often talk about the stub. So this is the lingo that is used in a lot of provinces, the stub requirements. Stub requirements are a statement. So prior to online payment processes and direct deposit, you got a paycheck and you told the stub off, and it told you what your year-to-date wages and what your weekly or period wages were. And it broke it down into different kinds of income, like vacation pay, regular pay, statutory holiday pay. It told you the type of income that you received on each check in each category. And it defines also what is allowed to be deducted from checks like Canada Pension Plan, tax, and so on, and what cannot be deducted from your paycheck. Things like inventory shortages. You can't penalize a person on inventory shortages and take it out of their wages. So these are illegal deductions. And of course, there's requirements for court orders that say, for example, if a person gets a court order to make a payment on money that's owed for something, then companies are required to follow the court order. If you're going to have any other type of deduction, like, for example, deductions for RSPs, which is probably a good thing, that a company says, oh, we'll match you make $1 deduction in your RSP, we'll match it by $1. Then you still have to have a written agreement that authorizes you to make that deduction. The employer does not have the authority to make that decision on their own. These written authorizations must specify an amount, a frequency, a method of calculation, and of course, it's not permitted to cover things like inventory losses or faulty work. Cash shortages are a little bit different. Cash shortages can be deducted in certain employment areas where, one, it's written clearly in the employment contract, and two, the employee is in a work situation where they are the only person with access to that cash. So for example, if you gave a person starting their shift, I don't know how, say, for example, a gas station works, but an employee comes into the gas station and you're going to be the only person behind the glass in the gas station. They give you your own float box and say, here, there's $400 or $1,000 of cash in this float box. And while you're on your shift, from the time you log in, you're the only person that's got access to the cash register and to the float box. And so if you sell $2,000 worth of gas, the credit card receipts, the debit card receipts, and the cash should add up to the $1,000 you started with, plus the sales. And if it's missing, it's because of you. There's no possible or other way that there could be a cash shortage. So there are ways to deal with cash shortages, but it's only in very specific situations where they've signed an authorization, it's written and defined very clearly, and if the person is the only person who has access to that cash. An employment agency specifically is prohibited in Ontario from charging a worker any type of fee or making a payroll deduction for things like being an employee. You can't say, oh, it's not, it's a good example. I'm long time ago, I'm sure that talent agencies where you would get sent out, where a person would get sent out for modeling assignments or for photography assignments or for something. So a talent agency would often charge a percentage. So the customer would pay $1,000, but the talent agency would take their 10%. This is not allowed in the employment and staffing services industry. You cannot charge a fee to a worker, or you can't charge a payroll processing fee. You can't charge them a fee for being an employee. You can't charge them a fee for helping to find them an assignment, or you cannot charge them a fee for helping find them a job. I would say that it's pretty much disappeared, but in the 80s and 70s, 80s, and 90s, there were a number of companies around, particularly around the 80s during the recession of the 80s, where companies would be in the business of coaching and counseling people on how to find employment. So they would take a course and they would get a consultant who would teach them how to find a job and help them do their resume. You can have a company that does that. You just can't be a staffing company that does that. So if you're in the business of being a staffing company, then you can't charge people fees for finding jobs. Giving information or advice, writing their resumes, none of this is allowed, particularly in Ontario, where it's specifically written into the code. And I think we'll find in common law in many other provinces that it's not allowed. Hours of work and weekly limits. Yeah, this is confusing, but in Ontario, for example, the maximum number of hours an employee can be required to work in a day is 8 hours. So, and then there's industries like the healthcare industry for nurses. There's union agreements where they say, hey, we work 12 hours all the time. So you can have an industry like healthcare, where it's often where there's exemptions in the legislation, but you can't say to a person, hey, the job here laying sod is 10 hours a day every day, 7 days a week. You can only, a person has to have time off. They have to have 1 day off in Ontario or in most provinces out of every week as a break. And in some provinces, you cannot require a person to work more than 8, which, by the way, doesn't mean that a person can't agree to work more than 8. A person can agree to work more than 8. And very often unions do negotiate contracts for 10, 11, and 12-hour shifts. And firefighters work 24-hour shifts. These are all parts of agreements that go beyond the 8. But in the normal circumstances, in the absence of an agreement, you can't say to a person, if you don't do this, you're fired. You must agree to this or else you're fired. If a person has the agreement in the first place, that's fine. Particularly if it's done under special circumstances like a union agreement or an industry exemption. But you can't just come along and say, I know you work normally 8 hours a week, but for the next 2 months, you have to work 12 hours, 8 hours a day. For the next 2 months, you have to work 12 hours a day. Otherwise, you're fired. Now, in Alberta, the number is 12 hours a day. In Ontario, it's 8. Same thing goes with hours in a week. So, for example, you can't require a person to work more than 48 hours a week on a regular basis. It's not to say that you don't have an emergency and you have to come to work to deal with the emergency this one time or once in a while, but you cannot regularly require a person to work more than 48 hours a week. And even if you do have a special circumstances in some provinces like Ontario, it gets capped at 60. So even if you have fire or a flood, you can ask them to work up to 60, but you cannot require them to work more than 60, even in a matter of emergencies. Ontario, overtime begins once temporary employee has worked over 8 hours in a day and 40 hours in a week. True or false? Well, we haven't covered that yet. It's on the next slide, I think, or next 2 or 3 slides, but the answer is no, you can't. Those numbers are wrong. Overtime doesn't begin at 8 hours a day. You simply cannot require a person to work more regularly, more than 8 hours a day. But overtime in Ontario begins at 44 hours a week, not 40 hours a week. So we've got some other things like a person must be given 11 hours consecutively off in each 24-hour period. So if you finished at 8 o'clock at night, they couldn't require you to start again until 7 o'clock the next morning, 11 consecutive hours. If you had some weird situation where, you had your 11 hours off, then you had a short shift, then you had to come back. You have to be allowed 8 hours off in between shifts. So if you worked for, 8 hours, then you had 11 hours off, and you came back for 4, you must be allowed to have 8 hours or more off in between shifts. Doesn't mean you can't agree to come back, but they can't fire you or reprise against you or tell you you're no longer in priority if they don't give you time off in between shifts. So things like a split shift are hard. If you're in the kind of job where you say, hey, you work 4 hours in the morning and 4 hours later in the day. If you don't have 8 hours in between, legally you can't set that kind of schedule up. Of course, a person could agree to it, but you couldn't mandatorily require a person to do that. 24 hours off each week. So, we talk about having 2 days off on the weekends, for example. The law is really 1 day off every 7 consecutive days. So theoretically, if you worked in a 2-week period, you had Saturday and Sunday off in the middle, that covers you off for the 1 week, Sunday to Saturday. And then you've got the 1 day off on Saturday, and then the 1 day off on Sunday that goes from Sunday to Saturday. So you could, the 2 days off on the weekend actually cover you off for 1 day off per week in a 2-week period. So these days of rest can also be combined into bundled into week periods. And Alberta has somewhat more flexible laws. My suspicion is because of camps, because in the oil and gas industry, often people go off for 2 weeks or 3 weeks or 4 weeks at a time into camp. Then they get a break and they're flown back out again, or they don't have to work during that time period. And so then they go back into camp again. And so they came up with legislation in Alberta that allows them to bundle to get together that says, all right, you get 2 consecutive days off, the example I just gave you, in a 2-week period, 3 consecutive days of rest in each 3-week period, 4 consecutive days in each 4-week period. So these can be bundled together. So for example, if you're working in camps, you can go in for 4 weeks, come out for 4 days, go in for 4 weeks, come out for 4 days. Each provincial government has got different rules. Nobody does this, by the way, but in Ontario, you need to you get a permit or permission from the Minister of Labor to do this bundling, unless you're in a specific industry like healthcare. So for example, I own a healthcare company, and lots of our people work in hospitals and home care on 12-hour shifts, and we're allowed to have 40 overtime calculated at 88 hours every 2 weeks, which could mean a person could work for 4 days, 12-hour shifts 1 week, 48 hours. So they're over 44. Then they get like 3 or 4 days off. Then they come back and work for 3 days, 12-hour shifts, 36 hours. The total of the 2 weeks do not exceed 88 hours. So I didn't have to pay overtime in the first 4 consecutive 12-hour shifts, and then the next week 3. Between the 2 combined, it averaged out to be less than 44 hours per week on the 2-week period. So that's something that you can do in the healthcare industry, but in other industries in Ontario, you need to get a permit to do that. Most people don't get permits for that. They're either in the industry, they're covered by a union, or at the point when they hired the person, they had them agree to that work style. And so the person agreed to it because in their opinion, that was better than the law. And remember earlier I said, you can't write an employment contract that's worse than the law. Well, if an employee thinks 4 days on, 4 days off, 3 days on, 4 days off, 3 days, 4 days on, if the employee thinks that's better, then they can agree to that in their contract. So most provinces set their overtime hours at 44 hours per week. and most provinces all pay time and a half. There are a couple exceptions. Number one, in some provinces, management is not paid overtime, time and a half, or 44 hours, or 40 in, I think, Manitoba, I think it's 40 hours a week. And we're going to look at another example, I think, in British Columbia in a moment that's really unique. But in most provinces, management is not included in the overtime rules. And yet you could have, imagine a retail store where a person is a sales clerk 3 nights of the week. After school, they go in and they work from 4 to closing, 3 nights of the week. And on Saturdays, they're the manager, because the regular managers during the week don't work on the weekends. And so they used to have a thing called the 50% rule that said that if 50% of your time worked was in a non-management role, then you were entitled to overtime, even if it included the management time on the weekend. And we have to check the legislation. Every province is different, but I think in Ontario, they've actually kind of lightened that up a little bit. So you can't, get a person to work, say, for example, 2 management shifts in a week and go up to 52% and then screw them out of their overtime. They need to be designated as a full-time manager in order for that to happen. Every province is different. It's just important for you to know, not to memorize what the hours are for each province. It's important for you to know that the legislation exists, that there's premium pay for overtime, and that there's definitions of overtime in each province and how it is calculated. BC, interesting. After working 8 hours in a day, a temporary employee must be paid time and a half. So it's not just 40 in BC, it's 40 hours a week. So if you work over 40 hours a week, it's time and a half. But to complicate matters, if you work 10 hours in a day, you get 2 hours of overtime automatically. So you might only work 10 hours in a week. You didn't hit the 40-hour requirement, but you hit the over 8-hour requirement in a day. So you get time and a half for the over 8 hours. And then furthermore, an employee gets 2 times, not time and a half, but 2 times the regular pay for hours over 12 hours. So if there's an emergency and you say, hey, I really need you to stick around for 13 hours, then they get double time. So check this out and how complicated this can be. And imagine what your payroll software needs to try to figure out, or somebody is processing timesheets. The person works 8 hours on Mondays, 10 hours on Tuesdays, 6 hours on Wednesdays, 13 hours on Thursdays, and they have a total of 37 hours in the week. So in British Columbia, this person did not meet the 40-hour requirement for time and a half. But on Monday, their 8 hours was 8 hours, so it was paid at regular time. On Tuesdays, their 10 hours is 2 hours over the 8-hour limit, so they get 2 hours paid at time and a half. Wednesday, they only work 6, so they had 6 hours as regular time. And on Thursday, there was something went on. The pipes broke. Somebody didn't show up for work. Something, and they end up working 13 hours a day, so they got their first 8 hours at regular time, the next 4 hours up to 12 hours at time and a half, and that 13th hour was paid at double time. So British Columbia has got the most complicated of requirements in the province. Most other provinces don't do that. They set a number of 40 or 44, and you're simply paid time and a half for the hours worked in excess of the total weekly total. Some provinces have minimum hours. By the way, we're going to take a break at 2:05. We're going to take a break at 2:30 for 10 minutes. So hang in there, and we'll take a 10-minute break and then come back and finish up for today. So some provinces have minimum 2 hours, some minimum 3. Ontario is minimum 4. And just so that you know, for example, in Ontario, and to get an understanding of how laws work, the minimum number of hours, so you couldn't ask the person to come to work for less than three hours in Ontario. up until about 2019. And so you couldn't say, oh, you better come to work for this 2-hour shift or you're fired. They said, hey, you gotta make it worth a person's while. So the shift's got to be 4 hours, 3 hours long or longer. Kathleen Wynne, the Premier of Ontario at the time, wanted to get reelected. She didn't. But she was grappling at straws, and towards the election made all kinds of election promises. And so they passed legislation that got through sometimes royal assent through final readings and passed into law. And some of them got held over until the next period. But they weren't supposed to come into force until after the election. It was a summer election, so she made all kinds of promises in the spring. The spring election, the election took place in the spring. The government won. The Conservative government won. They don't sit during usually July and August, and so they came back in September. And the first thing that they did when they came back in September is they reversed or repealed those legislations. So the government of Ontario said they were going to change it from 3 hours to 4 hour minimum. Many of us changed our employment agreements to comply with the new 4 hour minimum. And then the Conservative government got elected and came in. The first thing they did was they repealed that legislation and they went back to 3 again. So the companies that were slow on the uptake and didn't change their employment agreements, they just kept it at 3. And again, an example of how employment standards are often political decisions. They're passed in the legislation. They're often repeated and reinforced in employment contracts. And so we've got minimum numbers of hours. There's also restrictions on ages, on things like construction and drilling and heights. Lots of provinces have things like a 15-year-old not allowed to go more than 8 feet above the ground on scaffolding and swing stages. Also, 13, 14, 15-year-olds often can't work with pruning equipment and climb trees and work with arborists until they reach a certain age because of the risks associated with that. Some can't work in certain jobs without adult supervision. So these are all covered under provincial legislation. Employers often are required to deal with equal pay. So equal pay doesn't mean 2 people doing the same job must get paid the same. What it usually means is that if there is a gender difference between people working in the same job, they have to be paid by the same standards and under the same schedule. This is complicated, but it kind of goes like this. If 2 people are getting 2 different rates of pay, you have to ask the question, well, first off, is there a difference in pay? And you go, yeah, sure, there's a difference in pay. Is there a difference in the gender between the 2 people earning difference in pay? If they're both the same gender and they earn different wages, that's not a violation of the law. It's only a violation of the law if they're both of different genders and they receive different pay for the same work, and all the rest of the criteria I'm going to go through exist. So now we say, okay, they have different pay, they're different genders. Are the employees required to perform substantially the exact same work, use the same skills, to make the same amount of effort, have the same amount of responsibility on the job? If the answer to those questions is, yeah, they're all the same, it's the same, then we're moving more towards a violation of equal pay legislation. But they say, no. They do exactly the same job, except for one person is a supervisor. And they're responsible for telling other people what to do and asking them what to do, or to cover for other people, or the supervisor has to have all this safety training and the other workers don't, even though maybe there's not safety violations and they don't have to, do first aid or something. But they've got substantially different skills in order to do it, and different responsibilities. If they've got different skills, if they're different genders, different pay, different responsibilities, skills, or performance requirements, it's not a violation of the law. But if they're all the same, then we have to ask, okay, is now, is there a seniority system? Is one person been there for 10 years and one for 2? All right, that's allowed. Is there a merit system? One person lays 1,000 bricks a day and the other person lays 500 bricks a day? Is it based upon that's production or merit or quality? Is there some sort of quality assessment that they go through? And if they don't have any of those factors, then you say, okay, there's an equal pay violation. So you very, very rarely do you see an equal pay violation under law due to gender. But when there is, it's important that you have these standards in place and rules in place to make sure that men and women are paid the same or using the same system for the same or substantially similar jobs. So equal pay legislation in Ontario was a little bit different because when Kathleen Wynne came along in 2018, prior to the 2019 election, spring election, she passed legislation that was, or tried to pass legislation that said, well, geez, if you're a part-time employee, you have to get paid the same as a full-time employee. And if you're a temp working for a temp company, you have to be paid the same as the employees, the customer's employees. And it was just crazy on how would you ever even calculate this? And of course, they're not the same. Part-time worker is not the same as a full-time worker. A temp worker is not the same as a full-time employee. And so the legislation that I just described to you, where you went through this criteria to determine are they the same or are they different, wouldn't exist anymore because the Ontario government at the time said, well, we're just going to make it law that they're the same even when they're not. And of course, they didn't get elected. And so the next government came and said, well, they're going to throw that bill out the door and equal pay. And so, and equal pay is not to be confused with employment equity legislation. We're going to go through employment equity legislation tomorrow, which is entirely different, and it's federal legislation. So I'm not going to go into the details of that right now because we're going to cover it in detail, employment equity tomorrow. But equal pay legislation has to do with gender differences, and employment equity has to do with the balance of the numbers of employees that are represented in your workforce, which includes gender and others criteria. In most cases, written agreements between temporary employee and staffing services. I mentioned this earlier, that you can have exceptions, but usually you have to go to the Director of Employment Standards to get approval. For example, hours averaging for overtime pay. So these hours averaging agreements can average together different schedules, the 44 hours a week, 8 hours a week, so on and so forth. The lunch breaks. So I mentioned this earlier, once every 5 hours. So you can't say to an employee, technically, not sure. I mean, usually people have to complain in order to trigger a violation. The ministry doesn't go around saying, hey, I see these people eating their sandwich at their desk. Is this their lunch break? Did you give them a lunch break? They don't do that. The ministries typically deal with complaints, and then they go and look at a complaint on a case-by-case basis. And so we can't have an employment agreement that says you're not entitled to a lunch break. The law says that once you work for 5 hours, you have to be given 30-minute break. As I mentioned earlier, the coffee break is not considered an employment standards requirement. And so when you think about a lot of jobs where people are working from home or people are working at their desk, and they run out and they grab some Timmies and they come back again, did they get a 30-minute break? I think what's important is that you can't say to a person, no, you can't go. You can't go. The person says, hey, on my lunch break, I got to go and pay my bills, or I got to go get my food. I have to go buy some food. I have to stand in line. You can't say to the person, no, you can't do that. But we know that very often places have very flexible work environments, and employees and their employers work it out. And typically, lunch break violations are only taken into consideration where we've got some taskmaster employer who typically knowingly and wittingly violates the law and requires people to work beyond their schedule. Otherwise, people tend to be able to work it out. In most provinces, people are entitled to 2 weeks vacation in their second year or after their second year. Most vacation time is calculated after the period. So contrary to what we might typically think, when a person starts a new job, they're not entitled to, by law, to take their vacation in that first 12-month period. So usually what happens is, by law, the person works during the 12-month period and they accumulate their entitlement for their vacation. Then they take their vacation in the next 12 months. So theoretically, we're always in taking our vacation this year for what we earned for our work last year. In practice, that's not the way it tends to go. In practice, it tends to be like a person works for 6 months and they ask for their week off, and they get their week off in the summer, and then they work for 6 months and they ask for a week off at Christmas and they get their week off, and they might be borrowing against, some vacation that hasn't accrued yet. Um, uh, and a lot of employers are pretty flexible around that. They just, at the end of the day, they go, oh, well, a person worked for us for 4.5 years and they took 10 weeks vacation, but they only worked for 4.5 years. So they actually got 1 week's vacation more than they were entitled to. So some employers are pretty rigorous about that. Some are a little bit more flexible, but in theory and in legislation, you earn the vacation, it accrues or it accumulates, then you have to take it within a period after the accrual period. And usually, often, sometimes in provinces, you don't qualify for vacation until up to a certain period of time. Say, for example, it doesn't even accumulate up until your 13th week. That has, in most cases, been taken away. And so 2 weeks vacation is the equivalent to 4% of your earnings. So if you worked for 50 weeks out of the year, 4% of that would be equivalent to 2 of those weeks. And so out of a 52-week year, you work for 50, you get 2 weeks off. In Ontario, they enhanced the legislation. This was part of the McGuinty, Kathleen Wynne changes that the current government capped, and some other provinces are similar, that in Ontario, once a person's worked for 5 years or more of continuous employment, then they're entitled to an extra week off. So it goes from 4% calculation to 6%, or 3 weeks vacation. So the calculation is often, how should I say, the calculation can be in writing. It defaults to accruing or accumulating that vacation time and then paying the person their accumulated vacation time when they take the vacation. That's the default. But the legislation often allows a company to sign an employment agreement with a person where they get paid out during the period of every period of pay. So in the temporary help industry, temporary staffing industry, it is very common because people come and people go. And then how do you figure out in a year from now, if they've worked for you for 6 months and they left for 6 months, do we send them a check 6 months later? So in the temporary staffing industry, it's very common people sign an agreement that says, yeah, I'll let you give me my 4% vacation or my 6% vacation on each check. And so it's paid out with each paycheck and not accumulated. So, but that way, when a person does take their vacation time, 2 weeks vacation, say for example in the summer, they got no income during that 2 week period. They're taking 2 weeks off without pay. Whereas if it was accrued, like you might for a salaried employee or a regular hourly employee, you might say, hey, you worked for 17 weeks and we took 4% of your 17 weeks pay, we accrued it and put it in a balance, it's sitting there in the account, then you go and take your time off in the summer, we'll pay you out your 4% of your 17 weeks at that point in time. So you've got some income when you take the time off, which is how they deal with the fact that they didn't actually work for an entire year and then wait until the next year to take it. They say, hey, whatever you've taken up to your vacation point in time, we'll pay you your 4%. So you can sign an employment agreement to be more than 4%. You can say to a person, hey, your first year of employment, you're entitled to 3 weeks or 4 weeks. You can sign an agreement that's more. You just can't sign agreements less. You can sign an agreement that says, we'll pay you out on every paycheck, but the employee has the right to say no. That's not better than the legislation. I want it accrued. It almost never happens. I mean, I've been around this industry for 40 years and employed 50, 70, 100,000 different people, sometimes hundreds of millions of dollars of payroll a year. And I've never had a temporary worker say, don't pay me my 4% on each paycheck. But theoretically, it could happen. And the person could say, nope, don't give it to me. I need you to save it for me because I'm terrible at saving money on my own. Statutory holidays. We're going to talk about statutory holidays for the next few minutes, then we're going to take a break. Public or statutory holidays are defined by each province, and in I'm going to say the old days, up until around the turn of 2001, 2002, 2004, I can't remember. Some provinces, like Ontario, had a provision called the elect to work provision, where a worker who had the right to elect to work or not to work when requested to do so, which would mean a temporary worker, hey, do you want to take this assignment? No, but call me back if you get one that starts on Tuesday. My kids are off school on Monday. And then you call them back and say, hey, I got one that starts Tuesday. Yes, I elect to accept that one. Then they work until Friday. Then they offer them one for the Saturday and they say, no, I don't want to work on the weekend. And so they just go back on the roster. This is typical of what temporary help might look like. And that would have been considered under the old definitions an elect to work employee with the right to elect to work or not to work when requested to do so. Those people under that type of work arrangement were not entitled to public holiday pay. Over the years, in the last 20 years, province by province, this elect to work provisions have been removed in statute so that it didn't exist in statute for elect to work or in common law for elect to work. And it made it mandatory that all temporary workers, temporary employees, were entitled to public holiday pay. And each province defines what their own public holidays are. So, for example, in Quebec, Saint Jean Baptiste Day. Saint Jean Baptiste Day is a provincial holiday, but Victoria Day is not. So Saint Jean Baptiste Day is June, early June, a week or two after, I think. Correct me if I'm wrong on this. And Victoria Day is around May 24th. They're really close to each other. But in the province of Quebec, even if a company works for, say, for example, a company that takes off Victoria Day, the company is not required by law to pay them for Victoria Day unless it's in their contract. But by law, they are required in Quebec to pay Saint Jean Baptiste Day. In Alberta, for example, Remembrance Day is a public holiday. But in Ontario, as you know, the kids go to school on Remembrance Day, and we have our 1 minute of silence at 11 o'clock in the morning, and it's over with. It is not a public holiday in Ontario. But to make the point even better about the jurisdictional requirements for federal government versus provincial government. The federal government, banks are federally regulated, and banks are closed on Remembrance Day. And so you hear the expression, oh, it's a bank holiday, which is our colloquial or common way of saying it's a federally regulated holiday. That the federal government determines the employment standards for federally regulated industries. Banks are a federally regulated industry. And so Remembrance Day, the federal government has said if you're federally regulated, we're going to make that one of the public holidays. And so banks are closed that day. And so we call it a bank holiday. It's not really a bank holiday. All federally regulated industries are off on holidays that day. And only the provinces that have deemed it to be a public holiday is a public holiday in their province. So, let's think about Ontario again, because most of the people on the call today are not all, but are from Ontario. So let's just go in order. I don't know if they might be on the next screen, but let's just go in order, starting off on New Year's Day, public holiday. Family Day, third Monday of February, public holiday. Easter Monday, not Good Friday, Good Friday, not Easter Monday, is a public holiday in Ontario. So schools are closed because schools choose to be closed, but it's not a public holiday. So theoretically, Good Friday, lots of people have off, but they're not entitled to get paid. They're only entitled to get paid on Easter Monday. Good Friday, not Easter Sunday. What's next? Oh, May, Victoria Day, Canada Day in July. For Quebec, Saint Jean Baptiste Day. Here's an interesting one. The civic holiday in Ontario is the 1st of August. The civic holiday is recognized by the federal government to be closed as a public holiday, but in Ontario, it's not a public holiday. So the civic holiday is a weird one. It's not even mentioned anywhere in the legislation. It's sort of a traditional holiday where at one point in time, Simcoe County decided that it was going to become a public holiday, and they didn't really have the jurisdiction provincially, because they're not a provincial government, to determine that everybody in Simcoe County was going to get Simcoe Day off, which was the 1st day of August, until eventually all the municipalities started to pick it up. And then eventually companies started to treat it like a public holiday, i.e. paying people time and a half if they worked on the day, giving them time off in lieu if they had to work on that day, giving the day off to be at home on that day. And so it's become a tradition. There are no laws around the civic holiday, provincial laws around the civic holiday. So it doesn't get included on the list. And of course, we've got Labor Day, 1st of September, and then Thanksgiving in October, then Christmas Day and Boxing Day are public holidays. In the province of Ontario and other provinces, we've got various ways to calculate how much a person earns on a public holiday, but the requirement is typically this. An individual works for your company, whether they worked for 1 day, 13 weeks, some provinces are 13 weeks, some are 1 day. They work for their scheduled work day before the public holiday. In other words, they didn't take it off without permission. And they work their scheduled work day afterwards. In other words, they didn't take it off without permission. So you don't want to have people come along and say it's the July 1st Canada Day weekend and people take off Wednesday afternoon and take Thursday, Friday, and Tuesday off, and they take a super long weekend, call in sick those days. Those would be, they would not be entitled to a public holiday. So they work their regular scheduled work day, the day be immediately preceding and immediately following the holiday. Now, by the way, if you ask for the day off as a vacation day and you get it off, then your regular scheduled work day is the last day before your holidays, or the last day after your holidays. It was a not a regular scheduled work day if you ask for your vacation day. So you work your regular scheduled day before, regular scheduled day afterwards. Then we take the earnings in the 4 weeks immediately preceding the holidays, total gross earnings, take the average daily wage, and then pay that person that wage. So for a salaried employee who makes $500 a week, every week, it's $100 a day, it's pretty easy to calculate. For a temporary worker, works 12 hours one day, 4 hours the next day, don't work the next day. The rule is what I refer to as the divide by 20 rule. They take their total gross earnings in the 30 days immediately preceding the holidays. So that would be in a month, and there's typically 20 work days in a month, 4 5-day work weeks in a month. And so we take the 30 days earnings immediately preceding the holiday, divide it by 20. This simplified rule will help you to calculate very easily. So for example, if you pay biweekly, you say, what did you earn in the 2 biweekly periods, gross earnings on those checks? Divide that by 20. That's your calculated statutory holiday pay for the day off. Now we've got this example, then we're going to take a break. And this has to deal with the regular scheduled holiday. Megan ends a 6-month assignment on May the 26th. Canada Day is 5 weeks later on July the 1st. She's still considered employed but inactive during that 5-week period. Megan earned $15 an hour. She was available to work on May the 30th, but did not get offered another assignment between May the 30th and July the 1st. Because she was not terminated, she is deemed on layoff. In other words, continued to be employed, but not working. When July 1st approaches, she is entitled to public holiday pay. And so theoretically, we would take everything that she earned in the 30 days prior to the holiday, divide it by 20, and have to pay it to her anyways, but she didn't work. So her average is 0. If she had worked 1 day in there and earned $100 on that 1 day in the 4-week period, then we would divide that $100 by 20, and she would be entitled to $5, 1/20th of her total gross earnings. So here's some other examples. I'm going to leave those up on the screen. It's 2:33. We're going to come back at 2:43. Come back here. I want to just ask everyone, please don't disconnect and try to reconnect. That means I have to figure out how to let you back into the room. Just leave your microphones on mute and take your 10-minute break to 2:43, and we'll come back and we'll finish up the second half of our session when we get back. Okay, I'm going to mute mine also here, and I'll see you guys in 10 minutes. Second half of our session for today. I haven't had any people stop and ask questions during the first half. That either means that I'm boring the death out of you or explaining things well enough that we don't need answers to questions. Please take a moment while we just wait for a couple of people to come back on again. If you want to unmute and ask anything at this point in time, we can address your questions. If not, we'll get back at it real quickly. Okay. The recording has started again, so I'm assuming that means that I can be heard. We've got some issues with respect to public holiday. The example that was on the screen there is pretty straightforward. Manitoba public holidays, just to give the example that things can be slightly different. Employees who consistently work the same number of hours get 1 regular day's pay as a general holiday pay. So, for example, an employee always works 8 hours a day, 40 hours a week, would get their regular 8 hours of wages. For employees whose hours or wages vary, like temporary workers, general holiday pay is calculated at 5% of gross wages. Well, 5% of gross wages is divided by 20. Same math. So over a 4-week period immediately preceding the holiday. This is tactical. Technically, we're supposed to take every day's pay right up to the day's pay immediately preceding the holiday, which would be functionally extremely very difficult because the holiday might fall on a Wednesday or a Tuesday and the pay period ended last Saturday. And so typically nobody ever complains, never had a complaint in 40 years. We take the last 4 weeks of pay periods immediately preceding the holidays. I don't know if that would work. For example, if you only paid people once a month and the holiday was some on Family Day on the 21st, to go back and calculate what happened in January, that wouldn't be very fair. But for companies that pay weekly or bi-weekly, typically when they say the 4 weeks immediately preceding the holiday, as the industry goes, we go back to the last 4 weeks of pay periods, which might have started 3 or 4 days ago, immediately preceding the holiday, up to maybe a week or something immediately preceding the holiday or longer. But it's the easiest way and most rational way. As long as you consistently do that, it generally isn't a problem. But technically, we're supposed to be counting the 30 days or month right up to the day immediately preceding the holiday. So that can be functionally very difficult. I've never heard of anyone getting in trouble for taking the 4 weeks of pay periods immediately preceding the holidays, not the actual calendar days.
Dave, I have a question, if you don't mind.
Sure.
So I was wondering for assignment employees, I'm in Ontario. So for temporary employees who, let's say they are eligible, so they have eligible public holiday pay to be paid out, but they're laid off, excuse me, say 1 week prior to the holiday, but they've worked the 3 weeks prior to that.
Right.
If they're laid off and we don't have an anticipated return date, what is the recommendation or the yeah, you know where I'm going. So
Yeah, I
what's
know
the
exactly where you're
rule on
going.
that? Yeah.
Okay, so that's a really great question, and I got to be honest with you, I can't remember the order of the slide. So let's just jump into that, and if I come over it on a slide in the next little while, I'll just skim through it real quickly. So
Great, thank you.
we've got this notion of continuous employment, and it really came about with respect to our industry, temporary workers industry, but it exists in all industries. And continuous employment is based upon the principle that a person is employed until they're not employed, officially not employed. So officially not employed would be giving them a notice saying, hey, you're fired or you're laid off or the job's done. We don't have it anymore. Goodbye. And you give them a record of employment and you give them a written notice. And if they're entitled to any severance or termination pay, you give them that and you wipe your hands of it and they're no longer your employee. And if you don't go through those steps, then a person is theoretically continuously employed, but inactive. In other words, into what we call deemed layoff. So they finish an assignment and they don't work for a week or 2 weeks. You don't have a new assignment for them. You don't want to tell them you're fired. So you let them sit there waiting to get that assignment. You're anticipating, you're probably hope you're going to get an assignment for them, but you don't have one to promise for them. So you don't have a scheduled work day after. So in theory, when they come back to work, which might be in 2 weeks after the holiday or a month after the holiday, whatever. In theory, if they had any employment in the 30 days immediately preceding the holiday, their scheduled workday might be 3 or 4 weeks later when you finally get an assignment for them. And so in theory, technically, when you pay them their first paycheck when they came back to work, they should get their 1/20th or 5% of the gross earnings that they had in the 30 days immediately preceding the holidays. So the example that I gave a couple screens earlier was the person didn't work in that 30-day period, but they did qualify and they did go back to work after the holiday eventually, but they had nothing to calculate. And but let's just say, for example, they did work 2 out of the 4 weeks, then the assignment ended. You did not terminate them, so they're in temporary layoff or continuous employment status. So you calculate the 20, divide by 20 of their 2 weeks pay, not of the 4, because they didn't work for 4. So they're going to get a half a day's pay. It's going to sit in the queue. And then when they get offered an assignment, they go back to work, that becomes their scheduled work day. And then you got to pay them their half day. Unofficially, no, almost nobody does that. If there's a discernible break in the middle, most companies and most employees don't go through, most companies don't go through the hassle, and most employees don't ask for it. If it's an indiscernible break, like they work for you for 2 years and they take off a couple weeks a year, and 3, 4, 5 weeks a year, and those 3, 4, 5 weeks a year happen to be when you don't have work for them, then a company really should, legally, they should, do the calculation, treat their first day back to work whenever it is after the assignment as their regular scheduled work day, and pay them. Now, there's another whole set of rules about qualifying for continuity of employment. So, for example, if you phoned the person up and you said, hey, I've got an assignment for you, and they turn it down, and they say, no, I'm not ready to go back to work yet, or I got a job over at ABC Staffing Services and it doesn't end for a month, call me in a month, they no longer qualify. They've interrupted their qualification for continuity. So they're no longer considered to be temporarily laid off because you gave them a reasonable offer to return and they chose to not return, to not accept the offer. So when the continuity of employment legislation came out, there was a lot of training that went on in the industry, basically saying to people, hey, this could be a nightmare. Not only because of public holiday pay, but because of termination pay. Because theoretically, if you didn't give them notice of termination and the assignment ended abruptly, and they didn't get their 1 or 2 or 3 weeks notice, depending upon how long they've worked for you, then theoretically and technically by law, we owe them pay in lieu of notice. So what temporary staffing companies wanted to do was to say, boy, let's get them back to work quick. So that it was a temporary layoff, they came back to work so we don't have to trigger pay in lieu of notice. And then hopefully next time we know when the assignment's going to end and we give them notice, then we don't owe them any extra money. We say, hey, your assignment's going to end the end of next month. There's your 4 weeks notice. So this is your final completion date. And that's the end. so they were really encouraged to keep track of the offers that we made to people, so that if they did come back to work in 2 or 3 weeks from now, and we did owe them a half a day's pay or a day's pay or 3/4 a day's pay, if they had declined assignments in the interim while they were off, then we could justify them no longer qualifying for continuity of employment eligibility. So the short answer is, if they don't come back to work, they're not entitled because there was no scheduled work day after. If they don't come back to work and you didn't give them notice of termination and officially lay them off, you're going to be on the hook for termination pay. So you really want to call them back and have them refuse. And if you call them back to work and it was a reasonable period of time, and it was just like a week or 2 off, then keep track of it and pay it to them when they come back. And you're going to have you will have built it into your margin that you're paying people that 3.8% a year. You would have built it into your margin anyways, assuming that if the assignment continues, you're going to pay them anyways. Pay them their day or their half a day. You're going to have a very happy employee, and you're going to be in compliance with the law. So hopefully that long answer helped you out with it. But unofficially, turn the recording off. I think a lot of companies don't do a great job of monitoring that. They don't do a great job of saying, did the person come back to work? They don't do a great job of offering employment to find out if they're still available or would have been rejecting and they still qualify as temporary layoff. They don't do a great job of calculating it and paying people if they do come back to work. And generally, employees who've been off for 3, 4, 5 weeks don't even think that they're entitled to it. They don't ask for it. But potentially, it's a powder keg for many companies that don't pay attention to it, that if the Ministry of Labor came in and said, hey, let's do a detailed analysis of your 5,000 employees and see how many times you violated this rule, it could add up to be a fair chunk of cash. Okay. Confusing answer, not very straightforward. Let's take a look at what's going on. So public holiday pay. By the way, generally speaking, public holiday pay is calculated before vacation pay. Then it is, then vacation pay is added to it. So a person earns their public holiday pay and then they get 4% vacation pay on top of that, because public holidays are not vacation. So it's part of their gross earnings, of which they would be accumulating 4% or accumulating accruing days towards it. So if a person earns $160 a day, they would actually get $160 plus their vacation pay on top of that. You don't count their vacation pay in calculating their average day's pay. So if a person earned in the last 4 weeks $200 a week plus 4% vacation pay, when you go to calculate their average day's pay, it's based upon the $200 a day, not the $200 a day plus their 4% vacation pay, because that would be double paying them for vacation pay. If you took their $200 plus 4%, added them all up, came up with the $200 plus 4% average day's pay, then you added 4% vacation pay to it, you'd be double paying their vacation pay in that regard. So it's their gross regular earnings, not their vacation pay earnings. Okay, so a person works on a public holiday. By the way, I'm going to start talking fast because we want to get done by 4 o'clock and I'm not on schedule. So a a person works on a public, does not work on a public holiday, they get paid their regular days off. But what happens if a person works on the public holiday? So they're going to work on the public holiday and they're going to get that regular day's pay. They're going to get paid the regular day's pay that they would have got for sitting at home. That 30 days divided by 20, or average day's pay in the previous 30 days. They get their average day's pay as if they would have taken the day off and stayed home, plus time and a half for the time that they worked on the public holiday. So this is where you hear the expression, you can see in my little picture there, the little quotes, where is it? Double time and a half. There is no such thing as double time and a half. We use the expression double time and a half because if a person earns a salary or the same amount every day, and they get 8 hours pay every day, then they're going to get their 8 hours pay for being at home, plus they're going to get time and a half for actually working, which adds up to 2.5 times their regular pay. One for the regular pay, one for time and a half. That's double time and a half. So we have the expression double time and a half because it's get your regular day's pay plus time and a half for work on the premium rate for working on the day, adds up to be double time and a half. There's nothing in the legislation that uses that terminology, but of course it's easy for people to understand. You say, hey, you want to work on the holiday, you're going to get double time and a half. Well, they're getting time and a half plus their regular day's pay. Okay, so this is where I'm going to go quickly because of this termination of an assignment. An employee, termination of assignment is different from the termination of employment. Termination of employment is, as I described to you earlier, about, hey, you're done with us. Here's your record of employment. You're no longer employed by us. We've given you your notice. You've finished. It's not to say you're not eligible to be employed by us again, but you've broken the path of continuity of employment. It stopped. And so the end of an assignment, if you don't officially terminate employment, their employment has continuity. So there's this deemed continuity of employment unless you actually terminate their employment. If we provide them with a week's notice for an employee who's worked for a short period of time, or we give them pay in lieu of notice, then we can terminate their employment. It's the exact same terms for regular employees that it is for temporary workers. The only difference is in temporary workers, this notion of deemed continuity of employment is far more prevalent than it is in regular employment. Now, in regular employment, you might have a situation where you've got 100 workers and then their tariffs come up and the industry is hardly affected. So we're going to lay off 50 of our workers. And so 50 workers go into temporary layoff. And then there's this layoff period of 13 weeks. And during this 12-week period, it's 12 weeks. During this 12-week period, we're hoping that the tariffs come off again and we can call everybody back again. And at the end of the 12 weeks, if we haven't called them back, they're deemed to be terminated. We would have to pay them their pay in lieu of notice or termination pay. So you don't need to give people termination pay or pay in lieu of notice to lay them off. You're postponing that until the 12 weeks go by and you haven't called them back again. And if you haven't called them back again, then the government says, oh, you didn't call them back. So they're no longer, you can't keep them temporarily laid off indefinitely. Once you hit this 12 weeks, they're no longer laid off, they're terminated. So now you got to pay them their wages. So theoretically, in regular employment, you could have a person who's in layoff, then they get terminated, then we give them severance or termination pay. In our world, their assignment ends. So we didn't say, hey, you're laid off, but they become deemed laid off, just as if we had laid them off. We don't get assignment for them within 12 weeks. And technically, That's their termination date. Severance in Ontario. Now, there's this other thing. It's during a 12-week period, or and you can have this 35 weeks in a 52-week period. So you call them back, and then they go off for 4 more weeks. Then you call them back, and they go off for 3 weeks, and you call them back. So if you can't pull off 35 weeks in a 52-week period, it's the same thing as 12 consecutive weeks. So that's sort of how that works. In the case of termination with layoff, so we don't need to know more about that. A week is counted as an excluded week if, this is where we talk about when people are no longer eligible, if they're not able to work, if they're not available to work, in other words, they refuse an offer from you, if they're under some sort of disciplinary suspension, or if there's a strike or a lockout with the client. So these are the reasons why you can exempt a person from being qualified for their notice of termination. And to some extent, you can use it also to say, okay, they didn't come back to work after their layoff, and so therefore they're not qualified for their public holiday pay. You can use the same rationale for that. Yeah, so notice of termination is based upon how long a person works. So I'm not going to go into a lot of details because every province is just pretty much the same, but worded differently. It boils down to be pretty much the same thing. So let's just focus for now on Ontario. If a person works for any period of time less than a year, then we have to give them a week's notice. Now, it used to be years ago, it used to be 13 weeks. They weren't entitled to anything until after 3 months. Like in British Columbia, it still is. You can let a person go in their first 3 months. You don't owe them any notice. But in Ontario, that was removed. So a person works for a day, you're supposed to give them a week's notice. So if they worked for less than a year, supposed to give them 1 week's notice. If they worked for 1 year to 3 years, in other words, they're in their second year. They're in their second year. So they've worked more than 1 year, but less than 2, 3. So they're in their second year. We have to give them 2 weeks notice. And then they've worked for 3 years or more, but less than 4. In other words, they're in their third year. We owe them 3. If 3 or more, sorry, they're in their fourth year. Third year or more, less than 4. So they've worked 3 full years, but less than 4 full years, then they're entitled to 3. If they've worked 4 full years, but less than 5, they're entitled to 4, and so on, up to a maximum of 8 years and 8 weeks. The wording is slightly different in different provinces. You can see over here in British Columbia, after 12 months, you give them 2 weeks. So they're in their second year. Third year, they're in their third year, pay them 3, so on. Alberta has got the 90-day period. So you got to work for 3 months. But they've worked less than 2 years, they're only entitled to 1. So it's after they've completed 2 years, they're entitled to 2. After they've completed 4 years, they're entitled to 4. So look at this is the point is this. Notice or pay in lieu of notice are based upon the amount of time that you've had continuous employment, including those times between assignments, continuity of employment. So from the first day of employment to the last day of employment, it's based upon the amount of time that you've worked. Every province is slightly different. Manitoba's 10 years for 8 weeks. Ontario's 8 years for 8 weeks. Alberta's 8 years for 8 weeks. Some of them have got a 30-day waiting period. Some have got a 90-day waiting period. Some have no waiting period to get into the layoff, the termination notice. It's not important that you remember how to calculate it. It's important that you remember that it's required. because I've been doing this for 40 years, consulting companies, helping companies, doing stuff. And every time I got to look at their start date, got to look at their finish date, got to ask questions about continuity of employment, look at their employment contract to see if it offers them more than the statutory requirement. Then I have to remind myself and go back and look at the provincial statute because they change. I don't trust myself to know what happened in Nova Scotia last month in change of legislation. So it's important to know it's based upon time, it's based upon continuity of employment, it's based upon notice. And in the case of termination pay, you're allowed to give pay in lieu of notice. So you can say, we owe you 4 weeks notice because you worked for us for 4 years or longer, but we want you to leave this afternoon. So we're going to give you 4 weeks pay in lieu of that notice. But you could say to them, so your last day of work is in 4 weeks from now, which is typically what you would do with a temporary worker who's on assignment. You say, hey, your assignment ends in 4 weeks from now. We don't have any expectations of having a new assignment. So please consider this your notice of termination. And of course, you are eligible to be rehired again in the future. We love you. And let's hope that we get something else so we can reemploy you. So, and then you give them a record of employment at the end of their 4 weeks. So you can give people notice. That's the requirement in law. But you're also allowed to give them pay, the calculation of the pay that they otherwise would have earned in exchange for or in lieu of that notice. Now in Ontario, the term severance pay has a very specific meaning, and in general, colloquial, common words, it doesn't. So if you talk to a lawyer and they say, oh yeah, we're going to work out your severance package, that means what are you going to get for getting terminated, for getting fired from your job or leaving your job? But in Ontario, they differentiate between termination pay and severance pay. It's not, severance pay is not the same in the Employment Standards Act as termination pay. Severance pay is for long-term employees only that have worked for an employer for 5 years or more, including all the time spent by the employee through this continuity of employment. And the employer has a $2.5 million payroll. Now, most temporary staffing firms have $2.5 million in payroll, but not all do. And so as a result, you got to be big enough to qualify, and the person has to work long enough to qualify. And so, or it has to be 2.5 million, or you laid off, let go, severed 50 people all at the same time within a short period of time, 6 months. Which if you laid off 50 people, you had $2.5 million in payroll, almost for certain. So it's pretty much the same thing. And so severance pay is above and beyond termination pay. Oh, geez, got to go back. Don't have a table here for severance pay. What do you know? There we go. So severance pay is calculated pretty much the same way. It's another 8 weeks. So if the person's worked for 5 years or longer, if your payroll is more than $2.5 million a year, and if you terminate the person you are required to give them termination pay notice, termination notice up to 8 weeks. So in the case of the 5 years or more, it'd be 5, 6, 7, or 8 weeks of notice, or the equivalent of 5, 6, 7, 8 weeks of pay. And plus severance pay, which cannot be given in notice. It must be given in pay. So you can't say, you worked for me for 8 years, so I'm giving you 8 weeks notice, and that covers me for my termination notice and my severance pay. It's not called severance notice. It's called severance pay. You would have to give them their 8 weeks of notice, which they maybe work out, and their 8 weeks of pay. Now, this becomes an issue when you are terminating a consultant or a manager, somebody, administrative person who's worked in the office for 5 years, this isn't typical of a temporary worker. It's not common that you've got a worker who's worked for you for 5 years or longer, and then their assignment ends. And so theoretically, a person works for you for 5, 6, 7 years, you could give them their 5 weeks notice and not owe them anything more than that. But if you had no intentions of employing them again and putting them out with another client, then you still would owe them the severance pay. We don't hear about this very often. It's more likely the person works for you for 5 years and then they quit to go take a full-time job someplace else or somewhere else, but it is possible. So when it comes to temporary workers, consider severance pay, but more likely when it comes to an internal employee who's worked as an administrator, recruiter, consultant, or a salesperson who's worked for 5 years, and for whatever reason, we're going to sever their employment, we've got to consider termination pay and severance pay. Okay, we've got leaves of, sorry, go ahead.
Sorry, Steve, I have another question. Sorry.
Good.
With regards to termination pay, I know you had said even if an assigned employee works for 1 day and then so they're still owed the termination pay. What if they're terminated based on performance? Is that still
Okay.
applied?
Yeah, no, good question. There has always been, yeah, it's a really good question, and I didn't mention it. I should mention it. There's always the notion of cause for termination or cause for dismissal. Now, the definitions of cause are pretty vague. They go to common law. In other words, the courts have looked at this over and over and over and over and over again. Everybody in the world for 100 years has sued their employer. The employer saying, I'm firing you for cause. And the employee says, I didn't do anything wrong. I'm going to sue you for not paying me. And then they go to court and judges take a look at this stuff and it starts to become common law. In the legislation, it talks about willful neglect and willful misconduct. This can include things like theft, willful disobedience, disobeying instructions, intentionally causing harm to the company, intentionally harassing employees. So there's the challenge is that it's hard to prove cause. So it's another whole discussion about human resources practices and procedures. When a person starts to behave badly, let's say, for example, they are harassing another worker. So you go to them and you warn them and you say, hey, this is against our policy. It's against the law. It's a violation of human rights. It's a violation of the Employment Standards Act. It's a violation of workplace health and safety, workplace harassment protection laws. You're going to have to go and take this mandatory training and do this thing. And you put it in writing and then you suspend, then they do it again. And you suspend them with pay and you put it in writing and you tell them one more time and you're fired. But, that's typically the way that if you took a human resources course, they're going to teach you to document and use this progressive discipline methodology to justify your termination for cause. Not showing up for work is not cause. I mean, you say, I got sick, I got in a car accident, my kid, I got a call from my kid's school. This is not termination for cause. Performance, not meeting your sales standards, having a sales rep who doesn't meet their sales objective is not termination for cause. It's a good reason to terminate a person. It's a good reason to give them notice that they're being terminated because they're not meeting their sales objectives and that you're going to reorganize the business and find somebody else who can do the job or change the job or something. But it's not considered cause as in willful neglect, willful disobedience, or willful neglect, willful disobedience or willfulness. Um, so um, uh, it's a challenging question. They worked for one day. They didn't do a very good job. You don't want to have them back again. Whoa. Whoa. You know, when you're calculating 1 week's pay, you're actually taking what they actually earned, not what they were supposed to earn. So you're going to take their 1 day's pay and you're going to divide it by 30 days or 20 days. And you're going to pay them for like, half an hour, something like that. So it's more relevant for people who've worked for 2 or 3 or 4 weeks and you just say their performance is no good. So you got to calculate an average, what their average earnings are in the 30 days preceding. They've only worked for 3 weeks. So you got to give them 1 week's pay, which is really they only worked for 3 weeks. So, so the number gets lower. The whole notion around probation is frowned upon in some provinces. Terminating people without notice during a probationary period is being written into statute to not be allowed. And typically it's not an issue for somebody who earns, 15, 17, 20, 21, $25 an hour. Their performance is not good. You give them notice, you tell them they're done tomorrow. There's no issues around. There typically are no issues around it. People don't sue you for it. It's not even worth their while to spend the money on it. It becomes an issue when you go and hire and I don't know, let's say you go, let's take an extreme example. This did happen. I believe it was Ottawa Civic Hospital. They hired a president who earned hundreds of thousands of dollars a year, and something happened really early in the employment, and they terminated the person. And they tried to terminate them for cause. And of course, they were unable to prove the cause. And so they didn't go to the employment standards. They went to common law court and they sued. You can't, I'll come back to this also. They sued them in court for, remember that fourth type of law, contract law. So they said that the employer violated their part of the contract agreement by terminating the person's employment. And they went and took a look at what was their loss of income because they quit their other president's job to come and take this president's job. And the payout was very large. It was very large. And that was contract law. That was not what we're talking about here, which is employment standards, because employment standards goes to a maximum of 8 weeks, and it's got very rigorous and specific ways to calculate the pay. So the answer to the question is, it's usually not an issue. Certainly, but cause does not have to do with performance. It has to deal with willful neglect, willful disobedience, and not performance issues. So hopefully that answered your question. Again, long answer to a really good question. But a person who is terminated for cause is not entitled to termination pay or severance pay. Leaves from work. I'm not going to go into all these details except for the fact that there's different kinds of leaves in every province and they come up all the time. They get changed and added. Just this year, the Ontario government added, as I mentioned to you earlier, a new type of leaves for adopted children. But if there's a death in the family of a child, a parent can get up to 2 years off where they're allowed to have their job back. They don't get paid while they're off. These leaves are without pay. Loss of pregnancy also has 12 weeks. We know that pregnancy does, but for example, in this Bill 148 from 2017, I think it was, they added these loss of pregnancy, medical family leaves, child disappearance leaves, 2 years. Your child gets abducted or is lost, up to 2 years. I apologize in case you can hear my dog barking in the background, working from home. And I think there's somebody at the door. I'd like to throw in some other provinces. So in Manitoba, there's maternity leave, parental leave, family leave, for an employee to deal with family responsibilities or personal illnesses. There's bereavement leaves, 3 days in the event that an immediate personal family member passes away. Compassionate care leave for employees to care for a seriously ill family member. Long-term leave for serious illness. The whole illness thing too, 17 weeks. We always have this thing like, hey, they got sick. When are they coming back to work? And can you terminate a person while they're off sick? Well, the answer is no, you can't if they're legitimately off sick. And in Ontario, they've removed the requirement for people who call in sick for a day to have, or a short period of time, to even have a medical letter. This is becoming too much of a problem. Couldn't get a letter, so you're fired, kind of thing. It's like there was a certain point in time where you just got to trust a person when they call in sick for a day or 2 days or 3 days, they got the flu. You got to trust that they've got the flu. And then once it gets into weeks on end, then they can have medical letters, and that you're not even allowed to do anything about it in some provinces for 17 weeks or even longer. So different kinds of leaves. So again, when it comes to writing the exam for this, know that there's reservist leaves and organ donation leaves and different kinds of family leaves. You're not going to be required to remember every leave because every province has a different time period and every province has a different name for leaves that are seemingly similar. I'm not going to spend any time on this whatsoever, except for to let you know that during COVID, special provisions to the Employment and Standard Act were implemented where people could not be, they were in layoff periods, and the layoff periods extended beyond the 35 out of 52 weeks and the 12 consecutive weeks that I talked about earlier, that they just went on indefinitely until they were ended on July 30th, 2022. The Ontario government said, hey, look, you don't have to give notices of layoff. You don't have to do whatever. You don't count these weeks towards, people are continuously employed during this period. It's going to go towards their employment period. And the government just basically said, we're going to alleviate the thought that everybody's going to sue their employer for not letting them come back to work or telling them they can't come to work, or for the business shutting down because they had no work. And then they removed all that and they gave lots of notice as to when it was going to end so that people could be called back and the time clocks were all going to start all over again. In Ontario and in other provinces, we now have disconnecting from work. So people with 25 or more employees or larger employees, you notice that a lot of times they look at, oh, you lay off 50 at a time? Do you have 25 employees? Do you have 25 employees at the beginning of the year? At the beginning of each year, you count the number of employees. So it doesn't matter that some point in time during the year, you went up to 50, then back down to 25. So they're always looking for, mediums, not tiny employers. That we have to allow people to disconnect from work. They can turn their phone off. They don't have to answer the phone. They don't have to answer their emails. They don't have to answer their pagers, that you can't track them electronically. Ontario introduced this whole monitoring, electronic policy for monitoring. So you can imagine a trucking company puts a GPS system in their trucks. So they know where their trucks are, and so they know where their driver is all the time while they're in the truck. They know that while they're on duty, that the truck is parked and where it's parked and how long it's parked and how fast it goes. And we know that, for example, I mentioned to you, I own a home care company. So in our home care company, we don't know where our caregivers are at any given time, but we do know this, that when they go to clock in and clock out, they've got this GPS fencing. So we know that they're still at the customer's house when they can't clock in from the bus 5 miles away or from their house. The GPS says, oh, wait, you're not at the GPS location of the house. You can't clock in. And when they go to clock out, they say, well, you're no longer at the house. You can't clock out. You left early. So we tell them, hey, look at this is GPS monitoring. We don't really know where you are ever, except for when you click that button. When you click that button to clock in, and when you click that button to clock out, it tells us you either are there or you're not there. I don't know where you are, but we tell people the information that that is being tracked. That we can say to them, hey, you're trying to make an effort to clock in, but you're not there. Where are you? And it might have been that they arrived half an hour early and they put the person in the back of the van and drove them to a medical appointment, and now they're trying to clock in at 9 o'clock in the morning from the doctor's office. It might have been perfectly legitimate, but it allows us to track that kind of stuff. So, if a company issues you their phone, much the same way as you can track your kids and GPS tracking, location tracking on their phones, if a company's going to do that, they have to tell you. If they're going to put cameras in the office, they have to tell you. If they're going to record your telephone calls, they have to tell you. And so nowadays we've got the right to disconnect, so you don't have to answer the phone, and they also have the right to know when you're being monitored. By the way, it doesn't prohibit employers from monitoring their employees. It does say, hey, you better tell your employees everything that you monitor. And then they can choose whether or not that's acceptable to them or not. And if it's invasive or illegal what they're doing, then they can lodge a complaint about it, but you can't secretly monitor your employees and not let them know about it. We now have non-compete, I'm going to spend a minute on this. We now have non-compete clauses in prohibitions of non-compete clauses in employment agreements in Ontario. This was enacted in 2021. So, in employment, employers have concerns about confidential information. So somebody works for your company and you give them access to confidential information about your prices and about your special 12 spices in the chicken and all your special methodologies and who your customers are and all kinds of and your schemes and drawings and all kinds of copyrighted materials, training materials. These are all confidential information, and if they're reasonably to be expected as to be confidential, in other words, not available in the public domain, or if they're documented and told you that they're confidential, then companies have the right to protect their confidential information and to stop people when they leave their employ from people using that confidential information to the unfair benefit of the past employee and to the detriment and harm of the employer. We also have this notion of fiduciary duty. So fiduciary duty is when you give someone the trust to take care of something on your behalf. So a really good example that I like to give is your nanny is got the fiduciary duty to look after your child as if it was their own. They got to make sure that they don't fall down the stairs and they don't drown in the bathtub and they don't choke on their food and that they don't eat peanuts when they have a peanut allergy and that they get to school safely and cross the road safely. And so the nanny is hired and given a duty of responsibility called a fiduciary duty, which means that it rises to the level of the responsibility of the person who's giving you that responsibility. And so very often in customer relationships, we say, hey, this person's got a fiduciary duty to look after that customer on behalf of the corporation as if it was the corporation themselves looking after that customer. If it was the president themselves looking after that customer, they got to make sure that they're serviced well and their information is protected. So we've got this notion of fiduciary duty. And then we've got this other thing that is like non-competition, non-recruiting. So we've got things like other employees that work for us. Well, it's kind of like, it's almost like confidential information that if you work for a company, you're getting paid by the company, and you start to recruit your employees, sorry guys, I didn't turn off all my phones. If you start to recruit your co-workers and employees to leave with you to go work somewhere else, then you're violating some of your fiduciary duty and the notion of confidential information. You wouldn't have been given the relationship with those employees unless I paid you to come to work. And you wouldn't have been given the opportunity unless I paid you to come to work. So we've got these non-solicitation, to not solicit the employment of your coworkers and to not solicit the business from your customers. So we give the person responsibility to go and work for a customer, to look after a customer, to sell to a customer, to service a customer, to work at the customer's work site and do something there, fix their computers, do their thing. And so we say, hey, while you're working for us, we're not paying you to go there and impress the customer so that you can solicit them to go work to be your customer somewhere else. So the notions of non-solicitation, confidential information, and fiduciary duty are different from non-compete. The non-compete clause, which traditionally has been, and in other jurisdictions still exists, in a contract where it says, hey, you shall not work for a competitor and compete in our industry within 50 miles or 100 miles for 2 years or a year, this broad sweeping restriction was intended to say, golly, I can't really measure and monitor and look after non-solicitation. It exists in reality. You're not supposed to be soliciting my customers, but I can't police that. It's too hard to complete. How do I know you're secretly phoning people and sending them emails and buying them coffee? I don't know that. The notion of fiduciary duty, that you're taking the fiduciary responsibility you were given and you're using it to build a relationship for you and that customer or you and that employee. So I pay you to look after it for me, but then you kind of acted like the mom and stole my kid because the kid now thinks that you're your mom. Well, that would be illegal. So the notion of fiduciary duty is a real one, but policing it is hard. Measuring it is hard. And confidential information. We know that there's confidential information. There's no question about what confidential information is, but how do I know that you memorized it? And Justice Wyas-Chuck said that the memorization of information is tantamount to the physical theft of that information. But how do we police this and monitor and manage it? So I want to put these into the contract. So they came up with the concept of non-compete, saying, look, let's just say you can't work in my industry and compete for a year or 2 years within a reasonable geographical distance, and that'll cover off the non-compete, non-solicitation, and fiduciary duty, the harm that you could otherwise unfairly cause. If you can't work there, then you can't do it to me. And the government came along and said, yeah, no. You can try to impose your non-solicitation. You can try to impose your fiduciary duty. And you can try to impose your confidential information because they are measurable and they are real. But throwing a blanket over all of them and just saying, so therefore you cannot work in my industry in a non-compete, that's not fair. That's too much. You're probably restricting people from doing things that were never going to cause harm to you or are never unfair. So you can't stop people from doing that. So the non-compete clause has been removed. And so if you have non-competes in your contract, you want to have them changed, and you want to have your lawyers help you work on fiduciary duty, non-solicitation, and confidential information. For many, many years, up until the year 2004, there was employment agency licensing in the province of Ontario, and many other provinces also had the requirement for employment agencies, not temporary help companies, to have licenses in their provinces. And then in 2004, that license requirement was removed because it was pretty darned useless. In the 30 or 40 years that it existed in the province of Ontario, not one single company was ever penalized, put in jail, fined, or removed their license for the violation of terms of their license agreement. In other words, the government was taking $500 a year or $400 a year giving people a certificate to hang on the wall that said, boy, aren't you a legitimate company? You've got a license, and yet it meant nothing. So as an industry, we negotiated that they either enforce it or remove it, and they couldn't afford to enforce it, so they chose to remove it. Then here we came along to 2022, and the current government introduced a requirement to license not only employment agencies, but all recruiters, but also temporary employment staffing agencies, temporary staffing firms. So for the first time in Ontario, temporary help agencies were being required to be licensed, whereas they weren't before, and they were reinstating a law that required recruiters or employment agencies to hold licenses. And they gave about a year's notice, and then they delayed it, and then they delayed it again. And the implementation date was supposed to be 2023, July. And when that date came along, they didn't have even their website up for people to register. And then they extended it to July 1st, 2024, and companies, thousands of companies eventually registered. And even to this date, a year and a half later, they haven't fully approved all the applications. So they've given people, they've approved, I don't know, 60, 70% of them. In other words, they looked into the application and said, yeah, this is all truthful and accurate and so on. And there's no reason to disapprove of them. For example, they're not criminals and they've paid their taxes. So they've issued licenses. About 30% of them still are in a sort of a under review status because they don't have the staff to deal with them, and they haven't done anything yet with respect to enforcement. But this is now new in Ontario, and the reason for this are because of situations like, for example, on the Fiera Foods situation where there was a multi-million-dollar tax case, and other investigations where Fiera Foods was using a whole bunch of fly-by-night temporary staffing companies where the people would work for temporary staffing company A on Monday, and then they'd be employed, the same people, temporary staffing company B on Tuesday, which is really the same owners, but different corporations, and then temporary staffing company C on Wednesday, and they would move them around so that they would never have continuity of employment, and they would be terminated by this one and not by that, and they wouldn't qualify for vacation pay and pay in lieu of notice, and they were treating them as independent contractors and not as employees. And eventually, Revenue Canada went in and said, hey, you owe us all this money for tax withholding in the Canada Pension Plan and unemployment insurance. And the employees went after all kinds of other things. And eventually the government said, wow, these fly-by-night, really bad players, maybe if we license them, this won't happen. Well, licenses exist in Manitoba, British Columbia, Alberta, Quebec, and the Atlantic provinces. Most of the provinces are for employment agencies and not necessarily for temporary help agencies, but where they do, the issues are mostly about the dealing very often with temporary workers, and their biggest concern, and temporary foreign workers, and the biggest concern that they have is that these companies are going to come along and employ vulnerable people, not adhere to the laws and how they pay people. So pay them cash or pay them less than minimum wage, or not pay them vacation pay or unemployment insurance, Canada Pension Plan, or termination pay or public holiday pay. That they're going to take advantage of their lack of knowledge. And so they're saying, if you, and in Ontario, this is new also, they're saying to companies, if you do business with a temporary staffing firm or an employment agency that's not licensed, then the customer is going to be liable for violation of the law as much as the agency is. And they also came about and said, look, you got to have a bond or an irrevocable line of credit for $25,000, which basically means that if you don't pay these people, the workers, if you don't pay them because you faked like you went out of business, or you absconded with the money and you went away and didn't pay people, then the insurance policy, the bond, would pay them up to $25,000 total. Or the irrevocable line of credit, an irrevocable line of credit is when the bank says, we're going to allow this money to be in your bank account, but it's not in your bank account. In other words, you can never go below that number. You can never go below $25,000. That money is sitting there, so you better have a line of credit if you're going to go below 25,000 or something, because they're going to always hold that $25,000, knowing that at any point in time, the Ministry of Labor could come along and say, hey, we're calling on that line of credit. We need to collect $24,999 to pay unpaid temporary workers. So along comes this application process, and most of the provinces are the same. You have to provide contact information, the address of the location where they carry on business, or in other words, where the temporary staff. Oh, and by the way, the agencies, permanent placement agencies, now, we negotiated this, are only required in Ontario to get a license if they deal with temporary foreign workers. Or foreign workers. If they're recruiting foreign workers to come to Canada, or temporary foreign workers to come to Canada to work directly with a client, then they said you got to have a license. They said if you're just dealing with companies and recruiting people from Ontario for Ontario, then all the obligations are really on the customer. If the agency lied to candidates to get them to come to the customer is going to be in trouble for violations of human rights or whatever the law is that they violated. So licensing requirements for recruitment firms are only if you're recruiting foreign nationals or foreign workers, and for temporary help companies, a bond is required to protect workers in the event that they don't get paid. And the requirements are that you provide information as to who you are, what your email addresses and what your names of your owners are, the addresses that you're going to work out of. You're going to have to just tell them exactly the formation of your company, a partnership or a corporation, or who the corporate officers and directors are. They're going to have to take a look at all those officers and directors and determine whether or not they have other licenses in other jurisdictions and whether or not they have got any criminal backgrounds whatsoever. So they're going to take a look at the criminal convictions and so on and so forth of these officers, owners, and directors and partners. Information about the applicants engaged or using, if there are other companies that are involved that are partners companies. So this whole Sierra Foods thing where they had 2 or 3 companies that were all owned by the same people, but they moved the employees around. So you have to show their relationship between those. They have to show that they're in compliance with the Employment Standards Act and Foreign Workers National Act and Protection of Foreign Workers, Occupational Health and Safety Act, Workplace Health and Safety Act. You don't really, you have to click a box that says, yes, I'm in compliance. And I guess they've got some mechanism where they can, because these are all provincial things, they can look and see. Then there's this thing called a tax compliance verification number. So in case you don't know what that is, a person in your company who has got access to the Revenue Canada online portal can go to a section on the online portal that says, hey, I need a tax compliance verification number. Then they take a look at whether or not your Canada Pension Plan, tax withholding, unemployment insurance, GST, and year-end annual tax filing and payments are up to date. And if they are, they'll issue a tax compliance verification number that's good for a year. And so you then go on to a provincial portal and you upload the letter that is given to you, like the tax compliance verification number, once you figure out how to do it, which could take you forever because it's not straightforward. But once you ask for it, literally within minutes, you get the verification letter in a PDF form. And then you go to the employment agency licensing site and upload the compliance verification. And then you have to upload your documents proving that you have this $25,000 irrevocable line of credit from your bank or your surety bond, pay your $750 to help the government pay for all of this, and you can get your employment agency license. A reprisal. A reprisal is when someone complains about a violation that their employer is violating or might be violating something in the Employment Standards Act, and then you punish them for that by terminating their employment or reducing their hours or sending them to the back room, and any type of punishment for them asking questions or filing complaints with an ESA. It's called a reprisal, and reprisals are not dealt with lightly by the Employment Standards Branch. They issue big fines and penalties for companies that penalize their employees for asking for what they're entitled to. We got to hang on to records. You know, the answer is sometimes 3 years, sometimes 5 years. Different levels of government want you to hang on to things forever. I've always said to people, hang on to everything for 5 years, whether it's electronically, in digital format, in a banker's box, in a storage room. The reality is that you can be audited in some cases for up to 3 years. I think employment standards, 3 years, and for tax reasons for 5 years. Hang on to your records for 5 years. We got to hang on to records for 3 to 5 years for things like vacation pay, public holiday pay. We got to know who these employees are, what their SIN numbers are, when they went to work, when they took leaves from work, what hours they work. So those timesheets, electronic timesheets, or those pay stubs that show the timesheet, we got to know each day and week that they worked. So it's not good enough to just say, oh, you worked 40 hours in that 1 week period. We need to know when they put those hours in if we're keeping track and paying people by the hours. We have to maintain our wage statements. We talked about the stub. We've got to maintain that because governments can come back and can request information for up to 5 years. If there are any written agreements, vacation records, and so on, we need to keep that. So in Manitoba, some of the things are a little bit different. Start and end dates of annual vacations, the amount of any outstanding wages and outstanding vacation. You know, there's, in the case of accrued vacation pay, that's where a person doesn't take 4% or 6% on their each stub, but they accumulate the equivalent of that in a to be paid accrued vacation. So when they take it, it gets paid out. But then they leave your employ. You got to get that money in the hands of the person. So if a person works for you for a year and you've accrued vacation, then they just disappear off the face of the earth. You're supposed to make an effort to say, I still owe you $500, find them and pay them the $500. So of course, if you've got electronic banking and they have an active bank account, you can put it in that bank account. You know, in before 2000, I bought several staffing companies where when we bought the company, we found that they owed hundreds of thousands of dollars to past employees because temporary workers' wages were accrued, and then they'd work for 4 weeks and 4% of it would get accrued, but then they'd go work someplace else or disappear. And those employees would never ask for their vacation pay, never get it. There were 5 years. We had to keep the records for up to 5 years. We found up to 5 years of unpaid vacation pay. And we said to them, hey, you got to pay this stuff or we're going to deduct this from the price of we purchased from the company because we're going to pay it to somebody. And in fact, in the province of Ontario, nobody does this, but the law is that you're supposed to notify the government that says, I've spent 2 years trying to find this person. I can't find them. I'm going to give you this money to hold in trust in case they show up. So there's all kinds of different rules about the information you got to hold. Ontario temporary help agencies in the legislation, it defines an assignment employee and that they are the employee of the agency. It codifies, it now says in the law, instead of saying all employees are entitled to, it says, and if you're a temporary help company, you know they're entitled to public holiday pay and notice of termination and notice of severance pay and the right to equal work. Because as I mentioned to you before, there were this whole things about the elect to work and not to work, that they would say, oh, this is an elect to work employee. They're not entitled to it. So the government took that wording away of this elect to work exemption And not only did they say, and so therefore all the normal rules apply, and they said, all the normal rules apply. So we're going to double write it in the law. What an employment agency is, temporary help agency is, what a temporary help agency employee is, and what they're entitled to. So they double wrote it in the law to say, you're not different, you're the same. You apply to all of these rules, plus other rules that they can't prevent a client from offering a job to an employee, and that we can't charge a fee to the employee, put it right in the law, that we can't charge a fee to the customer after 6 months from the person being on assignment. So if we send a person on assignment and they're from 6 months from the day they start, and we had it written into the agreement that they can pay us a fee to hire that employee, if 6 months have gone by, that fee is gone. It cannot be charged. So they put also in there that we can't punish people for standing up for their rights. These are all things that are already in the law, but they felt like employment agencies, temporary help agencies, needed to be told specifically, and this includes you. There's also other more recent updates in some of the legislation in Ontario and other provinces, but in Ontario, June of this year, 13 consecutive weeks, after 13 weeks of consecutive employment, they're entitled to unpaid leave of absence for serious medical conditions that are certified by a qualified practitioner. Interesting, in the province of Ontario, starting July 1st, employers with 25 or more employees must provide new hires with written details about their job before their first day of work. So what they really found was that some employers in Ontario are saying, hey, okay, you're hired, you start Monday. And then people show up and they find out that they have to go to a different place, or they have to work weird hours, or they have a different kind of pay structure. So saying, nope, you got to put everything in writing before they start. They also came up with new employment rules about employment information. The league. Now, by the way, this is exactly, I'm going to go back a couple slides. Ontario employment agencies. Okay. So in the law, temporary help agencies must give the name of the employer, and they must give the name of the customer, and they must put in writing the amount of pay, and they must put in writing. That's all written in a special part of the Employment Standards Act about temporary help agencies. And then along comes this new provision. They said, well, if it's good for temporary help agencies, it's good for everybody else too. So these new rules say that every employer must say, hey, here's all of our legal names. So you can have, some places, our company's called iHowl because it's the website name and so on, but it's in-home assisted living. And so they have to say the legal name is In-Home Assisted Living Inc., operating as In-Home Assisted Living, operating as iHowl. You got to give all the different names so that people can't get confused about who their employer is and who's paying them. They have to give contact information, including addresses, telephone numbers, and more than one contact name of a person in the company. Before, you may not have got any contact names except for maybe your immediate supervisor. Now you have to put in writing more than one contact name for the employer. Now every employer, just like temporary help agencies, must give a description of where the employee will go to work, what their hours are, what their wages are, what their commissions are, how they're paid, when they're paid. Everything has to be in writing. These new provisions that came in July 2025 do not apply to temporary help companies because there's already, and has been for the last 7 years, provisions in the law that specifically say what temporary help companies are supposed to do. And the temporary help companies requirements go beyond this because it's the end date of your assignment, the customer's contact information, the customer's legal company name, so on and so forth. So they basically said, hey, this was good enough to give. Temporary help companies were bad. So 7 years ago, they put it into the law that temporary help companies needed to do this. And just this year, they said, well, I guess all employers are kind of bad. So we're going to get them to require them to do this also. And by the way, the driving reason behind this is because because of immigration in Canada and the numbers of people that arrive in Canada that just don't know what the norms are and what they're entitled to in the law. So now they're saying, okay, if you're not telling them and you're not putting it in writing, then you can get away with stuff. And so you need to put it in writing so at least people know in writing what they're entitled to and what's going on in their job. New legislation for January. ACSESS ran a webinar last week, 2 weeks ago, describing this in more detail. I'm sure it'll be done again, so watch for it and pay attention to some of the details through ACSESS. But basically, effective this coming January, temporary help companies must comply, well, all employers must comply with the new ESA job posting requirements, promoting transparency in hiring, ensuring a level playing field for job seekers. So, for example, employers must include information about the job posting with respect to their expected compensation. So you got to say, how much is this job paying? Or if it's a range, what that pay range is. So it's good and it's bad. I mean, they don't want people to, falsify information or not say information and then people become shocked. But it's a pretty big range, so if you're going to post a range that's it could be between, and it's over $50,000, it can be a $50,000 range, but you got to post the range. We also have to, this is something that we're going to have to really be concerned about. I mean, our job postings are going to have to say, hey, this job pays $30 to $40 an hour, $40 to $50 an hour, or more than $200,000 a year, or whatever. We're going to have to put that information in our jobs. We're also going to have to tell them this is an active job or it's not an active job. So you can say, we're a industrial labor company and we get lots of jobs at last minute all the time. So come and register with us and be ready to go because we might have a job for you tomorrow. You can do that. Or you can say, this is an open active job. We're recruiting for it now. But you're going to have to differentiate between what I call the evergreen jobs and the open active jobs. We're also going to have to disclose whether or not we're using artificial intelligence in any part of the process. Now, one of my companies used last year for about 6 months on a trial basis an artificial intelligence screening process where the artificial intelligence sent out information to people saying, hey, you want an appointment, use this thing, schedule your appointment, come into the waiting room. The artificial intelligence asked them some questions, they filled out a form, it assessed the form, it said whether or not they're going to proceed to the next stage. If they did qualify to proceed to the next stage, then they got the interview. Then during the interview, artificial intelligence listened to the interview and wrote notes about the interview and summarized the interview. It didn't work that great. It wasn't super. We're going to come back to that again. Lots of companies are using various forms of artificial intelligence. They're getting better and better and better every single day. ACSESS at the conference in May in Montreal had 3 sessions that were one way or another dedicated to issues around artificial intelligence. We're going to have to tell people that there's artificial intelligence being used somewhere during the hiring process and probably have to disclose to them where it's being used. We don't have to tell them what tool we're using or how it's being used, but we're going to have to say during this screening process it's being used and during this resume evaluation it's being used and notes are being accumulated during this, it's being recorded, and so on. We're going to be required to remove any reference to Canadian experience. So I guess the presumption there is that lots of people say 2 years Canadian experience required, and it's basically a false way of discriminating against people. That they might have excellent experience working someplace else, not in Canada or in school or something, and that it's a false way for us to eliminate people based upon discriminatory grounds. And so the requirement for Canadian experience isn't there. Doesn't mean you don't have to have experience, doesn't mean you don't have to have knowledge. You can determine in reviewing the resume or reviewing, going through your interview, whether or not the experience is relevant and important and valuable or not. But you can't just broadly say, oh, if it's not Canadian, it doesn't count, because it might very well be good experience and count. And so it just works out by broadly saying Canadian experience, it is, we'll talk about this tomorrow, systemic discrimination. I talked about disclosing the vacancy, whether it's evergreen or vacancy. And this is going to be the hard one for us, that we're going to, within 45 days of an interview, have to give feedback to the candidate to tell them whether or not the job exists or not, and whether or not they got hired, going to get hired, or whether they didn't get hired for the job. So we're all going to have to figure out how we start to provide notification to people. Okay, so that's it for joint liability. Is an interesting notion. We talked about this a little bit. This is when the customer shares in liability with you, so that you're not only responsible, but they are also responsible. This was included in some changes in 2014. Recently, in 2023, IT consultants and business consultants were exempted from the Employment Standards Act because the vast majority of them look like they're independent consultants. So where it says in the legislation, if there is an employer, the employer is going to be the staffing company, not the customer. But then they found out the vast majority of the time, if it's an IT consultant or a person earning a large amount of money, $65 an hour or more, they're probably an independent consultant and not an employee anyways. And so they basically said, it's kind of okay if they're a business consultant, a high wage IT consultant, to just call them an independent contractor and move on. And so these independent, they're dealing with operations and management and so on and so forth in these areas. So bottom line is that the Employment Standards Act's there to protect you. It's there to protect your workers. It's there to protect your customers. We've got a joint responsibility with our customers to make sure that we enforce it. The government will give us posters that exist for free online. We can download them. We can put them on our website. They also give us brochures that we can use in our office. I talked to you already about this co-employment, so I'm not going to go into great detail. This is the notion where the customer looks like the employer, and we've got a shared responsibility with our customers. Co-employment does not exist in employment standards, but it still does exist in areas of unionization. In other words, they can be our employee for the purposes of employment standards, but they can be the customer's employee for the purposes of participating in a collective agreement or a vote. It also means that they will be considered to be like an employee, the same as an employee, for many aspects of workplace health and safety. In other words, you can't have a workplace that says, oh, it's safe for our workers, but if they're the temporary staffing agency's workers, it's not, don't have to keep it safe for them. So in other words, they say, we've got a co-employer responsibility. Our responsibility as an agency to work with our customer to ensure that the customer is, in fact, providing a safe workplace, and we have joint and several responsibility there. Joint means we join together in ensuring that it's safe, and several means that they could sue us or fine us or charge us separately because maybe only one of us was at fault. But we start off as co-employers. So we mitigate our risk by talking about this with our customers, putting things in writing, and by sharing information with them, like, for example, inviting them to our office or us going to theirs, sharing our statements and our insurance policies and putting things in writing. And that way we can ensure that everything is not going to be up for argument later on. I talked to you about elect to work, so I can zoom through the, it's not a thing anymore. It's been removed. Talked to you already about charging fees to our assignment employees. It's against the law, and we can't charge fees to our customers after 6 months of them being on assignment. That is now against the law. You can send an email to me at steve.jones@bell. I'm just giving you my generic. I've got several business email. I'm giving you a generic one steve@bell.net. So it's Steve, STEVE, .jones, JONES, @bell.net. You can send me an email and ask me a question about anything that happened today that I talked about or talked too fast about, or you want more explanation about. Please feel free to do that. You can go online to the Retail Council of Canada and get those minimum wage and other things, or you can go to the government of Ontario or the government of British Columbia or Manitoba. You can download all kinds of great stuff, brochures, posters. There's special threefold brochures for temporary help agencies, all kinds of links and yeah, so we made it within 10 minutes. I apologize, I said we're going to go over. Tomorrow we will be more than 10 minutes quicker, but I open the floor to you so that you can jump in and ask me any questions before we leave today. And I'll stay online for people as long as you want. I appreciate you guys being so good. 3 hours is a long time. I congratulate you for taking the effort to do this. Today is a lot of information. Tomorrow we'll try to make it a little bit more fun. But I got to tell you, it's tough on me having a silent computer screen in front of me for 3 hours. So for those of you who did jump in and ask me some questions today, boy, I really appreciate you a lot. So any questions at all?
No, Steve,
All right,
thank you.
silence means you're asleep.
No, we are all good.
Nisha, any questions? You're good?
I'm good.
Okay. Thank you very much, guys.
For a wonderful session, Steve.
Pardon me?
Thank you so much for a wonderful session.